All right, everybody, turn your cameras on and stay on mute for me. Turn your cameras on and stay on mute. Missing some folks.
Yes, Your Honor, we did request a court reporter. How are you doing today?
Doing well. How about yourself?
All right.
Where's the other side? And sorry, I'm 3 minutes late, but I had to do my ex partes, and I hate when they overlap. Oh, there's somebody. Mr. Finley, turn your camera on. Take that background off, Mr. Finley. We're not advertising for anybody. Take the background off, please. Either you can blur it, but don't run some sort of IBM security stuff in the background. All right, now, that was just Miss Johnson. She just dropped off, didn't she? What I could do, same as I did the other day, make you a co-host if you want to use that as backup.
I'm gonna try again.
Thank you so much. I would appreciate that.
I'm here. Let me just shut down and try again.
Your Honor, my client says it says that she's here, but
Well, she's here now. I can see her.
oh, she says she see you now.
Oh no!
She says she see you now.
Oh, but I just shut off.
All right, so log back in. Just log back in.
Who's talking?
Okay, just give me
I'm sorry, Your Honor. That was my client. Your Honor.
Oh, you heard I'm like, where is she talking from? Okay, yeah, no, she's not on the screen, so she dropped off. So okay.
Goodness gracious, let me see.
Your Honor, I wanted to ask for a pretrial
I'm trying to.
Okay.
before we get back started. Once my client gets here.
Okay.
What's it now?
Judge Manning, it's saying that I need to ask the host to give me permission. This is the court reporter.
Oh yeah. Well, I thought I just make you the co. I thought I just made you co-host.
No, Your Honor, you made my counsel co-host.
Is Miss Danielle your counsel?
Yeah, because when it jumps around when people log on, let's see. Okay, I got Dr. Taylor here. Let's see. Just waiting on Miss Baya's client. The director of the family division is filling in for Miss Free, the case manager today. So we'll go very easy on her. Because Miss Free's top notch. And, you know, Miss Free's the best. So, Dr. Taylor, training wheels. We're just waiting on the other party. Dr. Taylor, let me make you co-host, Dr. Taylor. And we're just waiting on the other party. And then myself and the lawyers are going to go into a breakout room for a second. Did either of you hear from Judge Williams' chambers? Because I did.
I have not, Your Honor.
No, Judge.
I'll follow up. Judge Williams is at CLE. I'll see. All right, now she's here. All right, so Ms. Johnson, are you good with a pretrial?
Honestly, no, Your Honor. I would prefer to just go ahead and hop right into the hearing,
All right.
given how things have been going thus far. Let's just hop into it, Judge. Please, if you wouldn't mind.
Okay, so that's fine. We'll pick up where we left off. So here we are. Does either counsel know how it's been going since we last did the hearing?
Yes, Your Honor. My client could testify as to what's been going on. But nothing's changed since the last hearing, as far as I know. I'm going to call him for redirect anyway. The only thing that has changed is that reimbursement of attorney's fees. We're now up to $5,737.50, not including today's appearance and the hour it took me to get ready for this continued hearing, Judge, that my client is asking for reimbursement for.
All right. So
Your Honor, on behalf of, I'm sorry.
That's all right. Let me go ahead and make sure real quick. Are both parties going to share in takedown for Madam Court Reporter?
Medical reporter?
The court reporter.
The court reporter.
Yeah, sorry. My accent gets really bad. Yeah, sorry.
Okay. Mr. Finley, yes, we should share the takedown. trust me, Mr. Finley, we need to do that. We'll share the takedown, Judge.
All right, what about Ms. Baya? Is your client going to share a takedown?
Yes, Your Honor.
Okay, I require that the court reporter be paid within 5 days of receiving invoice. If she's not, let us know. We bring you back into the courtroom and find out what the problem is. You can purge from there, or you can purge from Rice Street. Both parties raise your right hand. Mr. Finley, Ms. Finley, this is a dry record, so take yourself off mute so I can get a verbal response. Mr. Finley, take yourself off mute. There you go. Yeah, I'll swear affirmative testimony you're about to give is the truth, whole truth, nothing but the truth. Ms. Finley?
Yes.
Mr. Finley?
I do.
All right, thank you. All right, we were on Ms. Baya.
That's correct, Your Honor. And Your Honor, at the time I had Mr. Finley on cross-examination. Mr. Finley, previously when you testified, you had indicated that you had not received any of the codes with regards to having access to the garage or getting into the house. Is that still your testimony today?
That is correct. That is still my testimony today.
Your Honor, if I will have the ability to be able to share my screen.
Sure.
1 second, I'm trying to pull it up. I apologize. Mr. Finley, do you recall receiving a text message from Ms. Finley regarding the codes that you had requested when the police were present on August the 15th?
No, with an explanation.
Go ahead.
The part of the TPO that is still in effect and is listed as in effect under all of the documents for the continuance of this proceeding, I have blocked her numbers. I cannot receive calls or text messages from her. And Verizon should have given her some notification that I don't receive those messages from her.
Okay, so if she would have provided that information to you, your testimony is that you would not have received it. Is that correct, sir?
Yes, if she provided it through that medium, I would not have received it. However, explanation, if she had sent an email, I would have received it. Text message, no. Phone call, no. Email, yes.
And during this process with regards to the divorce proceeding, have you all been communicating via text message or via email?
Both.
Was Ms. Finley aware that you were no longer accepting text messages from her?
No, with an explanation.
Okay.
In the TPO, I am not allowed to talk to her, contact her through any medium. There's no way I can block her from sending me an email, but I did block the other methods.
And the reason why I'm asking this question, sir, is that you had indicated that she had failed to provide information to you. But if I'm clear, and I just want to make sure I'm clear about your testimony, is that even if she attempted to provide that information to you, there was no way for her to get it to you because you were not communicating with her via text message, or you said via email, but there was no way for her to know that you did not receive her text message. Is that correct?
Well, no, counselor. As I stated before, because I have blocked her numbers, she gets a message from the carrier, Verizon Wireless, that tells her that this party is not accepting your message.
Okay.
Whether or not she received that, I don't know.
Okay, then. So with regards to the fact of your allegation that she failed to provide that information to you, you can't say certainly that she did not provide it to you. You're just saying you don't think you received it because you blocked her. Is that correct?
No, that is not correct. There were a couple of interactions where she was given the opportunity to provide it when the police were there, and she refused at those times. Now, if I'm allowed to share my screen, or maybe I can have my attorney give the video, and you and the judge can go in the breakout room and y'all can go through that yourself. But the video would clearly show that I had the officer show her where her key was and ask her for the alarm codes and the garage door openings. And if the video picked it up, you will hear her responses. I don't want to speak on what they were. Just let the video speak for itself.
I appreciate that.
You're welcome. Here to
Now,
help.
yes, sir. Now, with regard to your contempt, and I just want to make sure that we're reiterating, since I don't think we had a court reporter last week, is that you're alleging that there were cameras in the house, but you were saying that they were supposed to be removed, but they should have been disconnected. Is that correct?
No, the order said that they should have been disconnected. We talked about that last time after I read what was in the order back to you. It
Yes,
said
sir.
disconnected. And we also talked about how she disconnected those and that I never reconnected them again.
Okay. And the question I was stating to you is because we didn't have a court reporter last week, and I just wanted to make sure that the record was clear, is that with regards to your petition to have her in contempt, your contempt alleges that she should have removed the cameras, not disconnect them. Is that correct?
Mhm.
The order said that the cameras should be disconnected, right? And my cameras were in fact disconnected.
Yes, sir.
She installed cameras and those cameras were on and live and active. Now, I sit here at my desk. I can open up this little case here. These are all my cameras that were connected around the house.
Your Honor, I would object. I did not ask him to provide any exhibits in this testimony.
Finley, Mr. Finley,
Yes, ma'am.
please just answer her questions.
All right. Could you restate the question for me so that I can properly ask what you're asking?
Your Honor, if I can share my screen.
Yes, ma'am, go ahead.
Mr. Finley, can you see this document that I'm showing you?
I can. Give me a moment to rearrange the camera view here.
Yes,
Yeah,
sir.
and I'm going to object to this line of questioning. We've already been through this quite some time during the first part of this hearing. This is continuation. This is not an opportunity to repeat testimony that's been evidence that's already been provided. You've already been over this, Judge.
Your Honor, if I was just trying to make sure that we had a record of what the testimony was, it was the last about 5 or 6 days ago. I just wanted to make sure that we are clear as to what his petition is saying with regards to his motion for contempt and what the issues are with regards to whether my client may be in contempt regarding those matters.
Your Honor, then I need to have some clarity then. Did we totally waste 2 hours worth of this court's time last Friday when we were here and we're going to have to repeat everything that was said at the first part of this hearing because the court reporter was not present? I need to make some phone calls then because we're going to be here for another 4 hours, Judge. If that is what we're going to be doing here today, repeating everything that we've already went over.
Your Honor, my intent was not to repeat everything. I was just trying to make sure I hit the bullet points of why they filed their motion for contempt. But if the court does not wish me to, refresh the court's memory with regards to those issues, I can move on.
I mean, Ms. Bay, I've got my notes right here from last time, but if you have to ask him something on a follow-up, if you could just do that and let's just kind of move on.
I appreciate it. Thank you, Your Honor. Mr. Finley, I was showing you what has been marked as petitions number 21, which is regarding your motion for contempt. And I just wanted to make sure that I was clear that you were alleging in your contempt that our client, Ms. Finley, violated the court's order by failing to remove the cameras, not disconnect them. Is that correct?
Same objection, Judge. I was already asked and answered. Same objection.
Mr. Finley, if you can simply answer with yes or no, that would be so appreciated.
Counsel, could you scroll down to 21 since you referenced 21, please?
No, I said this is my exhibit number 21.
Oh, I
In
understand.
reference in paragraph number 11, your motion for contempt.
All right. And your question one last time.
My question was that you had put in your motion that the court had ordered that the cameras be removed. Is that correct?
That's correct.
All right. However, the court's order said just disconnect. Is that correct?
Your Honor, the documents speak for themselves. The order speaks for itself. The motion speaks for itself. He's already testified repeatedly. She installed the cameras. The cameras are still activated. They have not been disconnected. We have been over this at least 10 times now, Judge. He's
Okay.
answered.
Yeah, I've got that they weren't removed, they were disconnected. I've got it.
Now, Mr. Finley, when you previously testified, you had indicated that there was not enough distance between the Jack and Jill room with regards to where you all could sleep if you were rotating the master bedroom. Is that correct?
Yes, with an explanation.
So Mr. Finley, here's the thing. Everything doesn't need an explanation. Either it's 15 feet or no. I mean, everything does not need a dissertation. We went through this last time. It was like 2
I
hours.
understand that, Your Honor. The beds aren't 15 feet apart. So the answer is no.
So there, no. 15 feet is 15 feet. I got you. Go ahead.
Yes. So with regards to rotating the master bedroom, you all would not be able to sleep in the other rooms if you all were rotating the master bedroom and be able to maintain the 15 feet apart. Is that correct?
It's correct.
Now, with regards to the keys, you had indicated that you had changed the lock. Are those locks still with the original keys that you changed them to, or have they been changed back to the old locks?
No,
Know that they are with the original keys that were on the house before you changed the locks, or
No.
they are with the new keys?
yes,
They're with the new keys?
yes.
Okay. And since we were in court last, have you provided those keys to Ms. Finley?
Since we were in court last?
Yes, sir.
Yes.
And how did you provide those keys to her?
It's not a yes or no question. Those keys are in the garage hanging next to the door where
Okay.
they've been the entire time.
So you haven't really provided them to them, you just left them where they were originally left the last time, is that correct?
Yes,
Now, since you've returned, have you returned to the marital home?
I'm here now. Yes,
Okay. And since you returned to the marital home, is there anything that's different with regards to the marital home?
Your Honor, first of all, that's a very vague question. I don't know how you would be able to answer that. I would ask for a more specific question. Secondly, relevance, Judge. Again, we're here in a contempt matter. We're looking at Ms. Finley's actions, not Mr. Finley's. She's the one who's had a contempt action filed against her.
Your Honor, I've also filed a contempt action against Mr. Finley since the last time we were in court. The reason for my question, and I will be more specific, the court had indicated after court proceedings last time that Ms. Finley needed to remove herself from the master bedroom, and I just wanted to make sure the court understood that she complied with the court's order. Mr. Finley, is Ms. Finley in the master bedroom?
no,
And has she removed her personal items from the master bedroom?
yes,
And currently, with regards to the Jack and Jill rooms and with regards to Solomon, is there those rooms full to capacity now? Is there stuff everywhere in those rooms?
I do not know.
Have you been upstairs to the house?
Yes,
And have you been in the Jack and Jill rooms?
yes,
And is there stuff in those rooms?
yes,
And is there stuff completely filling those rooms?
no,
Can someone sleep in those rooms?
no,
And why not?
I don't know. Personal choice.
Mr. Finley.
Yes, ma'am. I'm sorry. I'm doing the best I can.
No, you're not, because now you're just really trying to be argumentative. Did somebody have the ability to go in there, lay on the bed and sleep?
Your Honor, there is a couch upstairs. I can sleep on that couch.
That wasn't her question, Mr. Finley. All of this is because, seriously,
Okay.
because I had to do, like,
No.
nesting on who, no, don't interrupt me, Mr. Finley. I had to do nesting on who's gonna sleep in a master bedroom. But now all of a sudden you say, I could sleep on the couch. So listen to her questions and please answer them. Go ahead, Ms. Baya.
Thank you, Your Honor. Mr. Finley, I was asking you previously, can someone sleep in the bed in the Jack and Jill rooms?
No,
And I ask you again, why not?
I don't have an answer for you, ma'am.
Mr. Finley, hypothetical. Ms. Baya asked me that question, I would say, Well, it's crowded, but the bed's wide open, sure. Or no, they can't, Miss Bea, because it's like a scene of hoarders and there's so much stuff you can't even open the door. That's an answer to her question, not you don't have an answer. Yes or no, is the bed open so that someone could sleep there?
No,
Or follow-up, why not?
because all of my possessions were thrown in array in that room. And I've been trying to sort them out in between work and work trips.
Things are spread out everywhere. Gotcha. Next question, Ms. Bea.
Yes, Your Honor. Is that both rooms, both Jack and Jill rooms?
Yes,
And with regards to Solomon's room, do you have stuff in Solomon's room as well?
no,
Now, with regards to, before you filed this motion for contempt, were you previously sleeping on the sofa?
before I filed the motion for contempt.
Mm-hmm.
Was I previously? Yes,
And throughout your marriage, have you been sleeping on the sofa on a regular basis?
sometimes. Yes, sure.
At least 3 or 4 times out of the week?
Do not know. I was not keeping a record. I'm sorry, Your Honor.
And prior to the TPO being filed, were you sleeping on the sofa more than 2 to 3 days a week?
No,
Now, Mr. Finley, you had indicated earlier with regards to you can't sleep in the Jack and Jill room. My question to you, what is your proposal as to where you and Ms. Finley, how you would rotate the master bedroom if you cannot use the Jack and Jill rooms?
my proposal?
Yes.
My proposal is she could have gone to Solomon's room when it was her turn to rotate out. Instead, she sort of moved in there and didn't move until last week while I was out of town. But that room was open and available for her the entire time.
Okay. And then the Jack and Jill rooms, did you remove those beds and put them in the basement?
Yes,
So there are no beds to sleep in that room. It's not because your clothes are in that room. Is that correct?
that is incorrect.
So you can sleep in there without the beds?
Yes, ma'am, I've already testified to my ability to sleep there without the beds.
And because there's a sofa that you brought up from the basement and removed the beds, is that correct?
I'm able to sleep on the floor.
Did you remove the beds and put a sofa in the Jack and Jill's room that has mold on it?
Just asked that, and my answer was yes.
Okay. And did you attempt to try to clean that mold off recently?
Yes,
And as a result of that, did you cause some damage to the property?
no,
Now, with regards to, and I had asked you earlier, with regards to your proposal, because you had indicated in your previous testimony that you all will not be able to keep a distance away of 15 feet as the court has ordered if you were in the Jack and Jill room. My question to you again was, how do you propose that you all rotate? Are you both rotating the master and Solomon's room? Is that the testimony?
no, the testimony is that I will rotate into the master when the master is available. Master was not available until I returned from my business trip.
And my question to you, Mr. Finley, and I apologize if it was confusing. My question to you is that if you're not in the master bedroom sleeping, where are you going to sleep during your rotation?
In one of the Jack and Jill rooms. As I've already testified, I don't need a bed.
Mr. Finley, you're paying Miss Johnson. She can object if it's asked and answered, okay?
Yes, ma'am.
So- Miss Bea is doing her job. Her job is to ask you questions to make out her case. And also, like I said, first year law school, they teach you to get under that person's skin, and she's doing that. So
Yes, she did.
stop it.
Yes, ma'am.
Answer the questions. Go ahead, Miss Bea.
Thank you, Your Honor. Mr. Finley, with regards to the garage opener, You had testified earlier that you cannot access the garage without the garage opener. Have you changed the code with regards to the garage?
No,
Have you recovered the garage opener?
no,
Have you put stuff all over the house where you're not able to actually see what's going on with regards to where things may be located in the house since you returned?
no,
With regards to Your Honor, that's all the questions I have at this moment.
All right, Ms. Johnson,
Yes, ma'am.
go ahead.
Thank you. All right, Mr. Finley, did you receive any indication from me that Ms. Finley had provided her attorney with the access codes to the garage door opener, and I was supposed to give that to you? Did that
no,
ever happen?
no.
You said that she's already moved things out of the master bedroom. When did that happen, sir? Before or after the filing of this contempt action?
After.
Has she moved things out of the master bathroom yet?
Yes,
And that happened after we have filed this motion for contempt, did it not?
correct.
You testified that there are things thrown in the Jack and Jill rooms now of your personal belongings. That was your testimony?
Correct.
Where were your personal belongings before the TPO had been issued, before you got back to the house?
They
Where
were,
were these things?
they were in the master bedroom
How long had they been in the master bedroom, sir?
since October of 2010.
And since October of 2010, who has been sleeping in the master bedroom primarily?
I have.
And you said that you do sleep on the couch, sir. How often do you actually sleep on the couch since the filing of this of the divorce? If you had to guesstimate, that's fine.
Probably about before the TPO, probably about 20 or 30% of the time. Since the TPO, I've been there most of the time
Why?
because I have to stay 15 feet from her, and by sleeping on the couch, I have access to every exit to that home if I have to sleep.
So is it your testimony then, just trying to clarify, that you are, when you do sleep on the couch, it's because you want to make sure that you can get away from her if you need to?
Correct. Upstairs in the Jack and Jill room, it's at the edge of a catwalk, and it is one way in, one way out. On the couch, I can go out the front door, the back door, the garage door, or the basement door, all which have an exterior camera facing it.
So you don't want, do you want to sleep on the couch in the family room or in the Jack and Jill room?
No, I don't want to.
All right. And sir, you and I did file that motion for contempt, correct?
Correct.
And you signed a verification for me, correct?
Correct.
And we attached that verification to the motion, did we not?
Correct.
And in the motion, we're actually asking that you not rotate the master suite, correct?
Correct.
What are you asking the court to do about that master suite?
Was asking the court to let me go back into the room where I've been.
Thank you. I'm gonna try to share screen now, Judge. I was practicing with this earlier. I make no promises, but I will try to share some videos here. I had it up earlier, now it's not working.
Yeah, it was just up. I don't know what happened.
That's not where I want it to be. That's
Oh, okay. So you have to, I don't know if you have, like I got multiple screens, my whole wall, because like, so you got to highlight that one window that you want to open. So if you got several, windows open, when it says share screen, make sure it clicks on the one that you actually want to share, or you'll share stuff that, like client list. And that's what I tell people, look, don't share till you got that one.
which is what I just did. I'm trying to get to my Google Drive. Here it is, Judge. I found it.
Mm-hmm.
And we're going to go to recent. And we're going to go to, you can see everything that I'm clicking because
No, we can't see anything.
Can't see anything yet. All I can see is you. So you haven't quite shared your screen yet.
All right, one moment.
There's something particular, maybe I can share.
Are you guys seeing that video, Judge?
No, ma'am. Just see you still. So it's not sharing.
Okay, one moment.
And when you go to share screen, if it's got audio, there's a little box at the bottom you need to check that says include audio.
I'm hitting share.
Hey, there you go. Now you're sharing it. Yep. There you go.
I need to go to my drive.
No, you actually have the video up.
I got this. Mr. Finley. Go. You had the video up. It was showed like some blinds. There you go.
Is that it?
It's showing some blinds in a room. Okay. Is it supposed to have audio?
I'm sorry, what was that, Judge?
Is it supposed to have audio with it?
I'll pause it until I can get it.
Well, so if you don't, when you go to share screen, if you didn't also click the box at the bottom when you first go to share screen that says share audio, I'm not going to be able to hear it. So if there's audio, you got to do that.
Okay.
They may have changed it now where you got to do something else, but I know before, like I said, Miss Free's a great teacher. You had to like click a box at the bottom when you first share screen. It says include audio or share audio.
I'm going to stop sharing for now. I'm going to hit share screen.
And when you do that, you see it where it says audio, bottom left or right.
Share sound.
Yep, there you go. That's it. So, and then like you did, you'll have it.
Okay.
And please, everyone, remember if you admit exhibits or anything, please email them to the court reporter. All right, and just unmute it there on your screen at the bottom of the video so you have it muted.
Is that it, Judge?
Yeah.
I'm doing well. How are you, sir?
I apologize for the length, Judge. It's about 5 minutes.
Okay, go ahead.
Want me to stay down here? Come with you.
This right now, stay down. I gotta escort her up. She don't get what she needs.
Okay. No, Officer Blaylock. So those keys right there in the door? This is the order from the judge. She's supposed to give me a garage door opener and access to this alarm system. And she hadn't done it. I had to rekey the locks. That's the key right there.
You have to redo the whole lot?
Yeah.
Okay.
Yeah, I'll explain it all to you. I mean, if she drives off, she drives off. But the court order says she's supposed to give me those keys. And my garage door opener. It's also the alarm code, too.
I'm not gonna turn up alarm on. I ain't gonna do it. It's like right now, because what's gonna happen is it's simple now. You have to go to court.
No, I understand.
Yeah, I was trying to be, I can't really make it.
Right, Doc. It's all good.
We didn't even come on because I like to turn it out.
I got you. Good luck to both of y'all.
Thank you, officer.
Well, hang on, Officer Blaylock. Just want to talk to you for a second. We'll go ahead and let her do whatever she's gonna do there. So, the deal is according to the court order, where
Okay. Mr. Finley, can you hear me?
I can't hear you. I placed myself on mute.
That's fine. So you shot that video, correct?
That is correct.
Right? You have not altered or doctored that video at all, correct?
I have not.
And in that video, you did in fact give her, or tell the police officer where the keys could be found, correct?
Correct.
And I'm going to let the video speak for itself, Judge, but in short, you asked for those access codes in front of the police officer and she refused to give it to you, correct?
Correct.
All right. I'm going to try to share something else. One moment. Sir, it was also your testimony that your wife did install some cameras, correct?
Correct.
And you also took video footage of that, correct?
Correct.
I'm going to try to share this video now.
tried to complain to the judge and having my cameras taken down. She put one up in the garage. I guess this is supposed to be an external camera, maybe? Not really sure. But this one has gone up at the same time. Camera that I had in the garage here, judge ordered that it be disconnected. So I don't know if the garage is considered inside the house or not, but if it is, we just have to find out what the judge wants to do about this additional new camera here. So it doesn't make sense that I have to take the one I had down and she can put one in.
Now, Mr. Finley, just to stay focused on that camera in the garage, do you see the color of the light that's blinking there?
Yes.
What color is that light?
Light is green.
So what does that mean to you that when the light is green on the camera?
That means that the camera is active, has an active power source, and is operational.
Okay, thank you. I'm going to try to share a different one now. Oh, Judge, I may just have gotten the hang of this. They still make no promises. Let's see here.
And I've been doing it almost every day for 2 years.
All right. You know what? Let's do something easy. Let's go here. Mr. Finley, do you recognize that?
There's just a list of stuff there. You hadn't opened anything for me to identify, Counselor.
Okay, one moment.
Tried to complain to the judge and having my cameras taken down. She put one up in the garage.
That's not it. I'm so sorry, Judge.
Okay, there you go. Click on the next one. You'll probably get it.
Basement window garage. Because I had it saved. One moment.
August 29th. And here's a camera.
Are you guys able to
That
see
is
that?
on after there's supposed to be no cameras in the house. All right. So go back up. It's the entrance door to the office where she is. So after having me take all the things down in my office, she's actually doing what she argued that I shouldn't be able to do. Okay.
Mr. Finley, can you tell me what's happening in that video?
In that video, they're actually on that day, probably about, I don't know, a couple of weeks ago, as I was walking to the couch to go to sleep, I saw that light was on and that camera was active and recording.
And where is that camera located, sir?
It's located inside of her office where she has exclusive access.
Thank you. Reset. Ugh, this is insane. I had everything up and ready. Oh, here we go. Maybe this is it. Okay. All right, there is testimony that you did not provide her with the key. Is that correct, Mr. Finley?
Correct.
And you also gave me a video of you doing just that, did you not?
Correct.
All right, so this is the location of the keys that I left for her. Leaving it in the door. This goes to all of the lower locks, and this goes to the glass door on the front. So she has everything she needs to enter. Assuming that the garage doors are still operational, she should be able to make it this far. If she cannot make it into the garage, she has also reprogrammed the keypads here and here. I no longer have access to those garage. I do not have my garage door opener. So for a while, I guess I'll only be coming in through the front door because I'm not going to talk to her.
Now, Mr. Finley, since the filing of this motion for contempt of court, has she given you the garage door openers?
No.
Has she, I guess she may have texted it to you, but did she give that, to the best of your knowledge, you should give the access codes to her attorney, who can then give it to you?
No.
Oh, give it to me so I can give to you? No. Okay. No, you already testified that you had to have the doors rekeyed, did you not?
Correct.
And why did you have to do that?
Because I got the order that I could return to the home on August 12th. She was unresponsive and would not answer the Google Nest doorbell when I came back with the South Fulton police officer. I tried again 2 days later. I got the same officer. I believe it was Officer Thompson. I had Officer Thompson call her and explain to her that I had the order where I could return to the marital residence. She acted as if she did not know that order existed, even though she had been in court with us that day. She acted as if she did not receive the email that came from the court, and she refused to give the access codes to the officer and the garage. So I informed the officer that I was going to have a locksmith come in and change the locks, because this was my second chance or my second attempt to come back to the home. And I need to get back to the home to get back to work.
Okay. Sir, do you see what's on my screen now?
Yes,
Okay, and what is that?
that is the bill from the locksmith where I had to have all of the access keys redone. That's the total bill. All exterior doors, all exterior
Okay.
glass doors.
Then we get that, it speaks for itself. How much did you spend on this?
$715.
Are you asking for reimbursement do you want the court to order Ms. Finley to reimburse you for that cost?
Yes.
Okay, thank you. I'm gonna try this again to show some photos that my client has taken. Okay, can you see my screen there?
Yes.
Okay. And I mean, you sent me a lot of photographs, did you not?
Yes, I did.
All right. And what are we seeing here?
We are seeing, if this is the long video, you're seeing a video where I returned to the home after attending an AA meeting in February, where I had some things that are written on the mirror there. Just basically some messages to myself to keep me calm and keep my head up. And the petitioner came in and wrote over those things, insisting that I should leave.
Okay, and we have, one moment, Judge. I'm trying not to scroll through every single photo and every single video, but honestly,
Yeah,
I'm just gonna stop when there's something I think is pertinent. That may be faster. I'm struggling here, so. Mr. Finley, what are we seeing here?
that is the kitchen area. Over on the left side on the counter, you'll see where most of my things there are assembled, and then the other stuff is just common space, but my
All
thing mostly in the corner there.
So when was this picture taken, before or after the issuance of the current order?
This was before.
This was before. All right, one moment. All right. This is why I like in-person hearings sometimes. Mr. Fanning, why don't you just describe what the master bedroom looked like when you got back into the house?
When I returned to is it permissible for me to share?
That would be great if you can. Is that going to be allowed, Your Honor?
I object to him sharing, Your Honor.
Well, I mean, he emailed her the exhibits and he knows what she's going to use. I mean,
I understand, Your Honor, that none of those exhibits that she has presented to the court have been admitted. So again, I object to him sharing. He's not an officer of the court with regard to presentation. He is represented by counsel.
well, he's not, but if she can't share her screen, I'll let her share her screen. I just really would like for him to stop making argument and just answer questions, because y'all don't have all night. You know, I got criminal hearings at 4:30, 5 o'clock. So.
And I appreciate that, Your Honor, but she is not doing, she's redirected and also added some additional evidence. So of course I get an opportunity to cross-examine him about these things.
You do. Go ahead. Tell him what picture you want him to share. Do you know which one in particular you want him to share?
Yes, Mr. Finley, there are photographs of the master bedroom and of the master bathroom. Can you pull up those photos and share with the court, please?
All right, we're here.
Okay, thank you. If you could go to the second row and the number is ending in 72. Do you see that?
Yes.
Click on that, please. What are we looking at here?
So in this picture here, we are seeing the inside of the master bedroom. This is the side where my things were. This is the volume of things that she moved into the master bedroom. I'll stop there.
Okay. And who took this video?
I did.
When did you take this video, before or after the issuance of the order?
Right here, August 14, 2022, the day that
So it's after, Judge, after Mr. Finley.
yes.
Please, Mr. Phillips, before or after? Answer the question.
Yes, ma'am.
All right, you can get out of that photo now, please. Thank you.
Yep.
Okay, and scroll down a little bit more, please.
Sure.
And these are all photographs of the marital rest, the master suite, correct?
Correct.
All right. Click on the one that ends in 79.
Which row are you looking at there?
It's on. It's the top row. Yes. All right. And again, what are we looking at here?
We're looking at the other side of the Jack and Jill sink in the master bedroom and the items that were on the floor.
Now, does this fairly and accurately depict the surroundings at the time that we had left court, the last time we were in court last week? When did you take this photo?
This was taken on the 14th.
All right. So again, she had not abided by that order, correct?
Correct.
All right. Thank you. And there should be another photo of messages that she left for you in the mirror, correct? Do you know which ones I'm talking about?
There were. Yes, I do.
Can you find those, please? Now, you already testified that sometimes you left messages for yourself, but click on, is it 64?
63, 65, 64.
Okay. All right. What are we seeing there, Mr. Finley?
So what we're seeing there are the messages that I had to myself. It says, stay calm, breathe, pray, then respond, one day at a time. every 5 minutes, which is saying I could do something healthy every 5 minutes. And then over that, she wrote on there, if you cared about Solomon, you would stop delaying the process and divorce without drama or something like that. The other photos actually show what she had there. You should sign the papers for us divorce and stop prolonging the process.
All right. So in other words, she was asking you to move out.
Yes.
And since the filing of this divorce, how many times has she insisted that you move out of, or you vacate the marital residence?
3.
Okay. All right. And would you agree with the court's conclusion, which is actually in that order, stating that there has been no finding of family violence on your part?
Correct.
All right. Judge, I would like to tender all of those photos and videos into evidence.
Any objections, Ms. Bell? You're on mute, Ms. Bell.
I do object to the last one that was up, Your Honor. Opposing counsel made statements as to what it was supposed to say, but the message was sign the paperwork. So, you know, if you love Solomon, I object to that being admitted because it was not a statement of him moving out of the house, which he has just testified to. With regards to numbers 79 and 72, I think there was some, I couldn't tell. He said it was the master bathroom, and then he said the Jack and Jill bathroom. I think the court had said move your stuff out of the master bathroom, not the Jack and Jill. So I'm objecting to the pictures with regards to what was in the Jack and Jill bedroom. With regards to the kitchen, the video on the kitchen, I'm objecting to that because I think it was unclear as to whether that is since he's been moved back into the home versus prior to before he had exited the house. And again, I wasn't sure as to what date and time that photo may have been taken with regards to when he may have returned or since he's been there. I'm not clear about that, so I'm objecting to that video. With regards to the keys videos, Your Honor, the officer, you see him with paperwork, you hear him, you know, talking to Ms. Finley, but you don't really hear him actually say to her, here's the keys to the garage pad, you know, here's the keys to the house or anything like that. So I'm objecting to that video as well, Your Honor, because it does not depict what he is alleging that it's depict. He keeps testifying as what was said, but it is not what's been said in the video. So I'm objecting to that as well, Your Honor. And I think that's it, Your Honor.
You want to respond, Ms. Johnson?
Yes, Your Honor, those aren't real objections. Those are oral argument or closing argument. I'm not hearing any objection to the authenticity of these exhibits. I believe that they should be admitted under objection, and you as the fact finder judge is the one who's going to determine what those what the evidences speak to or what they say.
I mean, I'll let it in for what little weight I'm going to give them. I'll let him in. I mean, one, he says he wrote notes on the bathroom mirror for himself, and then one was for her. And he did say Jack and Jill, and I've got some notes. I mean, I'll let it in for what little weight I'm going to get it.
Your Honor, again, the reason I wanted to share that with the court and in this hearing is because from the very beginning, I've been saying that she's filed this TPO just to get an advantage in the divorce action, and she's upset that it's going to take some time to get in front of the judge. That's why she filed this, Judge. She's been after him to move out of that house since the beginning of filing of the divorce, Judge. That's all.
I understand. I mean, I'll let it in for what little weight I'm going to give, but.
Your Honor, do I get to cross-examine again?
I have one more question, Judge.
Okay, go ahead. Go ahead.
Mr. Finley, you have incurred attorney's fees as a result of having to respond to this TPO, have you not?
Yes, ma'am, I have.
All right, and we've also filed an affidavit in support of our attorney's fees. So you already saw that. That's part of the record, correct?
Yes, ma'am, I have.
And since then, since the filing of that affidavit, we've had to come to court. I have to prepare for trial and so forth. You saw that, correct?
Yes, ma'am.
All right, would you agree that the total amount that you've been billed for this, just for the TPO, is about $5,737.50, Mr. Finley?
Yes, ma'am.
Is that more or less than what you have been billed for the actual underlying divorce?
More.
Are you asking for reimbursement of those attorney's fees?
Yes,
Why are you asking for reimbursement of those attorney's fees? Why do you think that's fair?
because this is totally unnecessary and just malicious to pursue this avenue. And to cause me to have to go through all of these expenses to defend myself.
I have no further questions, Judge.
All right. Follow up, Ms. Bear?
Thank you, Your Honor. Mr. Finley, one of the exhibits that your attorney presented was with regards to your receipt for your keys that you had put into the house. Is that correct?
Yes,
And that receipt was dated August the 14th. Is that correct?
yes,
And when you returned to the house on August the 14th, Ms. Finley was not there. Is that correct?
yes, and yes.
Now, with regards of how did you get into the house on August the 14th if she was not present?
I used a locksmith.
Judge, that's all been asked and answered. He's already testified to this at least 2, if not 3 times.
Your Honor, I'm only asking with regards to the fact that he just admitted into evidence with regards to receipt, with regards to the keys. So I was just trying to make sure that I was clear with regards to that.
Okay.
Now, with regards to the keys, you had indicated that you left the keys in the door, and in the video you make the comment, I'm not going to talk to her, but I'm gonna leave the keys right here for her. Is that correct?
Yes,
Okay. Now, with regards to the cameras that was in the house when you returned to the house, again, Ms. Finley wasn't there, but the camera was in place in the garage. Is that correct?
yes,
And Ms. Finley did return on August the 15th. Is that correct?
yes,
Now, with regards to the August 15th, when she returned, that's when she returned with the officer. Is that correct?
yes,
And when they were in the house, you did not make any mention about the video cameras. Is that correct?
no,
That's not correct, or that is correct?
yeah, that's good, good, good. I'm glad you clarified that. Yes, I did not make a mention.
And when she was outside of the house, you did not make any mention about the camera as well. Is that correct?
That is correct.
Now, with regards to the kitchen and the kitchen that you presented some pictures with regards to the kitchen, it was with regards to demonstrating that there was just stuff all in the kitchen. I just want to get clarification as the purpose of that picture that you were trying to demonstrate.
I didn't put that picture up, man. I don't know how to answer that.
Okay. And with regards to you returning to the home, isn't it true that Ms. Finley wasn't present? She was out of town with regards to you returning to the home, and you decided to change the locks versus just waiting for her to come to the home. Is that correct?
Objection, Judge, asked and answered. Repeatedly asked and answered.
Yeah, he changed the locks. I got that.
Now, Mr. Finley, with regards to the contempt that you have filed against Ms. Finley, isn't it correct that before the TPO or anything was filed, you and Ms. Finley both had items in the master bedroom? Is that correct?
Yes,
So with regards to the items that were still there when you returned on the 14th, when she wasn't there, were the items that was already there besides her sleeping in the bedroom before you returned? Is that correct?
no, that's not correct. There was more stuff there.
But the majority of the items that were in the closet was items that she already had in there. Is that correct?
Only half of the closet was occupied by her. She took everything I had and threw it in the other room.
Threw it in the other room, sir?
Yes, ma'am.
Okay. Your Honor, I have nothing further for this witness. You want to address the attorney fees, Your Honor, but I assume that I don't have a copy of the affidavit. I understand that opposing counsel says it's still part of the record. I have my office trying to retrieve a copy of it. I do wish to go through and challenge the attorney fees, but I'm not sure if you want me to do that with Mr. Finley or with his attorney.
Yeah, we can do that after we're finished. Anything else, Ms. Johnson, for him?
No, Your Honor.
Mr. Finley, why didn't you just call your son and ask him for his keys? That's a question for you, Mr. Finley.
Why I didn't ask him for his keys?
I mean, when you found the locks, you couldn't get in. Why didn't you just go by? He's at Morehouse. Pick up his keys and let yourself in.
Just trying my best to keep him out of it, man.
Oh, y'all aren't keeping him out of it. I
did.
pointed that out last week. Y'all are not keeping him out of it.
Can I say one thing, ma'am?
Nope. I wanted to know why you didn't go by and get the keys. Y'all have any other questions for him?
I don't, Your Honor.
Ms. Johnson?
No, Your Honor.
All right. Anything else? Ms. Bam?
Your Honor, yes, my client wishes to testify.
Okay.
I wasn't sure whether Ms. Johnson was finished or not.
Ms. Johnson? She said she didn't have anything else for him to you, Ms. Johnson. I'm sorry, I thought I just asked.
Nothing more from him, but again, we've already had an evidentiary hearing. Your Honor already had.
Well, this.
Okay, never mind. Go ahead.
Well, I just want to make sure that I'm clear, Your Honor. This is a contempt matter, and Ms. Finley does get an opportunity to defend herself against the contempt. We also did file our contempt matter. I understand it may not be on the court's calendar. We would ask that that be scheduled as well. The court can hear that matter with regards to her contempt. But with regards to this particular contempt, my client is ready to proceed and testify.
What is the plan for this house?
Well, Your Honor, it's my understanding that both parties want the house. So Judge Williams is going to have to make a determination. And I've explained.
Stop, Mr. Finley. Are you texting your lawyer? Because I know you're not sitting in the middle of my hearing, kick back like we're back on the block, texting somebody. Unless you're communicating with your lawyer, you should probably pay attention. I can't believe it. All right, so go ahead, Ms. Bria. Both parties want it.
Your Honor, it's my understanding that both parties wanted the house. That may have changed since then. I know my client still wants the house. I know there's an issue with regards of the fact of who gets what equity. There are also some real estate property that the parties have that is rental property.
Is that empty? Is any of that property empty?
It was my understanding that one of Mr. Finley's houses was empty. I'm not sure if he moved somebody in there. It's my understanding that his mom is staying in another one that he also has as well.
Your Honor, we're getting to issues of the divorce at this point. I don't think that's appropriate at this time. But to answer your question, we don't know what the judge is going to do with this house. The judge is either going to order it to be sold or is going to order that one of the parties remain in the house. Again, toward the beginning of this hearing, there was quite difficulty with my client being displaced from this house, which is why I filed the motion for an emergency hearing, the divorce action, and which is why I was very specific in my response to the TPO. It is extremely difficult for him to be out of this house because of the type of work that he does, and that house is actually hot-wired to his job, Judge.
And of course, Your Honor, we dispute that. We believe that everything is cloud-based. That his employer has advised him that he does not have to be at that house. It is what he is choosing to do, Your Honor. But at the end of the day, it's his word against hers as to what is relevant when it comes to this house. At this point, Your Honor, Ms. Finley is ready to testify. He's admitted that he has moved furniture into the Jack and Jill room. That furniture is molded. That furniture has caused my client to have some medical issues now. And she's prepared to testify to what has been going on. I do believe, Your Honor, part of the testimony that was earlier was with regards to my client giving me the codes to give to Ms. Johnson, to give to Mr. Finley. But, as the court is aware, I was not representing her in the TPO matter. So I'm not sure why she would have been giving me the codes to give to him. But nonetheless, Your Honor, we are ready to address the contempt. I believe that if the court does find my client have not complied completely, I think it is not willful, and I think she can explain to the court why she did the things that happened since the court's order, which she wasn't even home when the court's order was initially issued, the file version of the order.
Did both parties take all of this time to sit back and think about what y'all are fighting over?
Yeah, like I said before,
I mean, no,
they say it takes two people to tango and it takes two people to fight. Not this time, Judge. Not this time.
oh no, both parties were out of control last hearing. I mean, out of control. But this is something, and I can tell you, Judge Williams may make y'all put it up for sale and both of you move out. I'm just telling you. That's a possibility. So hopefully you guys are thinking of something, but I mean, I'm not. What is it that's so hardwired on this house that he has to be in this house to work remotely? What is it that makes him have to be there?
Well, that's going to be a question for my client to respond to, and I can certainly do that as well. But let me just say this one last thing, Judge. This is a court of equity. This is a court of equity, and we're asking the court to do something that is fair. And what would have been fair was her to keep the peace and keep the status quo until the divorce judge had an opportunity to hear all of the evidence and all of the facts of this case, and then make a determination. He had been in that master suite since 2010. Now, with that said, Judge, I will let my client answer that question. He's better at it than I am. Would you like for him to respond to that question?
Better at it than you are. I don't know if he can answer it directly without going on some sort of like diatribe. Can you answer it directly, Mr. Finley? What is it that's so special there, hardwired or something at that house? What is it?
So these are the machines. I can't do anything about the focus, but these are the machines that I use.
You got everything blurry, so you can take your blurred background off. That's exactly what you can do. Can you not just tell me, sir? Answer the question. Just answer.
The machines I have, I do demonstrations for CTOs and executives at major corporations and government officials. I develop things here. They're very powerful machines. They simulate cloud-based computing.
May I ask a follow-up question to that, Judge?
Sure.
What type of security clearance do you need in order to do your job, Mr. Finley?
I work on federal, state, local, hospitals, and major corporations.
Mr. Finley, you did not answer her question. What clearance level do you
secret level clearance?
Okay.
Maybe more.
When you
I did not hear you. I did not hear you. You're speaking at the same time. What kind of clearance level?
Up to secret level clearance.
Mr. Finley, I need for you to explain in layman's terms, okay? How have you been displaced from your home? How did that impact your ability to do your job?
Everything that I was developing for customers for demonstrations, I had no access to. So I had to have those meetings rescheduled, moved, and changed until I could get back to this environment to take the work I was doing and upload it somewhere else.
What type of internet connection do you need in order to do your job? And why can't you have that at your mom's house?
I have fiber here. I create simulated networks that are up to 500 gigs in size, and they are uploaded to other environments. My mom's internet is like 30 megs. It's ridiculously slow.
Okay. And what specifications or special adjustments have you made to the equipment at that house in order for you to do your job to your fullest capacity?
The rack that I showed you was blurred. There are two 20-amp circuits that are pulled under here so that this room can be powered without affecting any other rooms in the house. It's also hardwired all the way down to the internet connection. There is no wireless connectivity to my house, to my office. It is hardwired.
And I'm sorry, Judge, just two more questions. I know you're ready to go.
No, I'm just listening.
And it's my understanding that Miss Finley does work out of the house as well, correct?
Correct.
And what does she do?
Forecast, I believe a forecast analyst for hobby
When did she begin to start working from the house, from home?
during COVID.
So in 2020?
Yes,
And how long have you been working from home?
since February of 2010.
And in your opinion, would it be easier for her to move out and still be able to do her job than it would be for you to move out?
Yes,
Why do you say that?
because all she has is a laptop. She can go to a wireless connection and be anywhere. She does not have the physical dependencies on machines that I have.
And she also has rental properties, does she not?
She does.
All right. And she can go, could she not?
Yes.
And she makes 6 figures, does she not?
No.
Not quite sure what it is. I think it's between that and her rental income. It should be over 6 figures.
Okay. Thank you.
Now, Your Honor, I get the opportunity to cross-examine him about this, correct?
Sure.
Mr. Finley, you indicated earlier that you can't work out of your mother's home. So when you were out of the house during the TPO, you indicating you weren't able to do any of your work?
No, it didn't indicate that I couldn't do any of my work.
Is your testimony that you are not able to do your work unless you're physically in this house?
My testimony was the work that I was developing and working on up until the time of that TPO, I had to abandon it because I couldn't come back or get to it.
My question to you is it your testimony that you cannot perform your duties for your employer unless you are located at that house?
That's incorrect.
So you are able to create and do the things that IBM requests of you, whether you are physically in that home or at another location. Is that correct?
That's incorrect.
Now, with regards to you working from home since 2010, before COVID, how often did you travel for work purposes?
Your Honor, while he's pondering that, Judge,
Your Honor,
may I
I did not interrupt her, Your Honor.
Your Honor, my battery is about ready to die. I need about 30 seconds to grab my charger. That's what I was going to say.
How about everybody take a 3-minute break? We'll be right back.
Thank you.
Thank you, Your Honor.
Mr. Finley, turn your camera back on. All right, go ahead, Ms. Baya.
Thank you, Your Honor. Now, Mr. Finley, we were talking earlier about your work. Now, you indicated that you've been doing your the type of work you're doing since 2010. Is that correct?
That is correct.
And based on the type of work you were doing, you used to travel quite a bit, at least once or twice a month. Is that correct?
That is correct.
And it's only since COVID that you had to reduce the traveling. Is that correct?
That's not quite correct.
Okay, so your testimony is that before COVID, you were still you were not traveling about once or twice a month?
I've received 3 promotions since COVID.
Since COVID? Congratulations.
Thank
And
you.
with regards to those promotions, you do quite a bit of work with regards to the government, which you stated earlier about. Is that correct?
That is correct. My first promotion was to the federal team.
Right. And you are setting up different designs for them that you physically go and help them out with regards to that. Is that correct?
That's correct.
Okay. And you're able to do that work even though you're not physically at the house. Is that correct?
When I was on the federal team, yes.
Okay. Now, with regards to this hardwire equipment, you used to have more service than you have right now. Is that correct?
That is correct.
And they came and removed some of those servers. Is that correct?
That is incorrect.
So you have the same number of servers you've always had?
Correct.
Okay. Now, with regards to being cloud-based, is it your testimony that your job is not a cloud-based job?
That is correct.
You're indicating that you have to be hardwired no matter what you have to do with regards to your work. Is that correct?
That is correct.
What is the name of your supervisor?
Johnny Smith.
Now, you know that's funny. Now, with regards to Mr. Smith, if he was to testify, would verify that you need to be hardwired to do your job?
Ma'am, if I call him, he will get on the phone.
My question was, if we testified to the fact that you need to be hardwired, you have to be with your machines. Is that correct?
Yes, I nodded my head to the affirmative.
The court reporter can't take a nod. I'm sorry, Your Honor.
Sorry, you need to speak. This is a dry record. You need to say yes or no.
Yes,
Now, Mr. Finley, you had indicated earlier that your mom's house does not have the hardware that you need. So is your testimony is that you cannot perform any of your job duties any other place but in that physical home? Is that your testimony?
are we talking about my mom's house? I cannot do it from my mom's house. I can't do it from here.
Okay. And based on the fact that you can't do that at your mom's house, it's your testimony that if the court was to order you to have to leave the house and the house be sold, that you're not going to be able to do your work?
That's correct.
Now, with regards to property, how many rental properties do you own?
2.
And is there a reason why you can't move into your rental property?
Yes,
And the reason would be because you need hardwire?
because they're occupied.
Now, with regards to because you testified earlier about Miss Finley, so I get to ask you about this. You said she has rental property. Is it true her rental property is occupied as well?
I do not know.
Okay. Now, with regards to income, you don't know what Miss Finley makes. Is that correct?
I only know what was put in the discovery packet.
Okay. How much do you make a year?
Objection, Your Honor, relevance.
She asks about my client's income, Your Honor. I think I have an opportunity to ask about his as well.
Go ahead, answer the question, sir.
Approximately $152,314.
So you make more than enough that you can be able to relocate if need be. Is that correct?
No, I don't.
You don't think 150,000 a year is enough to relocate?
No, I don't.
Okay. Now, I just want to make sure I'm clear. In the past, you have worked in Germany or Australia and various countries. Is that correct?
That's correct.
And still having your servers at the house. Is that correct?
That's correct.
And you've been in DC and Florida working while you still have those servers at the house. Is that correct?
That's correct.
Your Honor, I don't have anything else with regards to asking him about his employment and the servers. I still do want to have an opportunity to have my client testify with regards to defending herself against this TPO.
You have any more follow-up, Ms. Johnson?
No, Your Honor, thank you.
All right, go ahead, Ms. Bea.
And I misspoke against this contempt matter, not a TPO. Ms. Finley, if you would please raise your right hand. Do you affirm and swear that the testimony that you're going to provide to the court today is true and nothing but the truth, so help you God?
Yes,
Please state your name for the record.
LaQuasha Deshelle Finley.
And Ms. Finley, you're the Ms. Finley that is a party of this order that the court has entered back on August the 13th of this year. Is that correct?
Yes,
Now, when did you receive that order from the court?
I looked at on the 14th, I think it was the 14th, August the 14th of 2022
And on August the 14th, 2022, where were you?
in Biloxi, Mississippi.
And why were you in Mississippi?
A friend of mine had passed away
Okay. And how long were you down there?
for 4 days.
So when did you actually arrive down there?
Oh, apologize. I have to look back at the calendar.
If you don't recall, that's fine. When did you return back to Atlanta?
On the 15th of August.
Now, on the 15th of August, when you return, you return with the police escort?
Yes,
And why was that?
because the respondent was in the home already and I didn't know what I would walk into. And I fear for my safety.
Okay. Now, prior to the court having a hearing on the TPO matter, and we're not going to get into the facts of the TPO matter, after the hearing, you had left the house to go to Mississippi with regards to your friend who had passed. Sorry for your loss. So between the court hearing and the 14th, tell the court what you did with regards to being in the house, your stuff in the house, and everything that's in the house. If you would explain to the court what happened with regards to the stuff.
Yes, half of my stuff was already in the master bedroom. So I just moved my items from one of the Jack and Jill rooms all into the master bedroom. So I actually just pushed all of my stuff into the master bedroom and neatly placed all of the petitioner stuff in one of the Jack and Jill bedrooms, the one to the fourth bedroom, put everything neatly. It was even a walkway for him to go around. The only thing that I could not put into that one bedroom was a very large sofa that was in the master bedroom. It was a green sofa. That green sofa I put to the basement because there was no space in the house for it. Excuse me.
Ms. Finley, I'm
Yes.
sorry.
No, the other room was left neatly attached to the Jack and Jill bedroom with a bed and dresser as well.
Now, this is what you done once the TPO was entered. You had moved the stuff around in the house. Is that correct?
Yes.
You didn't do this after you had the court hearing on August the 5th or 6th. Is that correct?
No, I did it before that time.
Okay. And so what happened after the court had issued the ruling with regards of removing those items from the master bedroom? If you would explain to the court what happened with regards to that.
So I moved so I did not move my stuff out immediately. Once I did read through trying to understand everything in the order, but I did move all of my stuff. There was no place for me to move back into the Jack and Jill room because it was occupied. Craig had the petitioner had put furniture that had never been in the house. It got molded like in 2012 and he's supposed to throw it away and he didn't. That was put in one bedroom with his stuff, and then across the other hall, it was just stuff spread out everywhere. And he had also had stuff in the closet. So I have my stuff lined up on the catwalk. I have stuff in Solomon's room stacked up, and that's actually where I'm sleeping now on half of the bed. My clothes are on one half, and then I'm sleeping on the other half of the bed in Solomon's room.
Your Honor, if I can share my screen.
Sure.
Ms. Finley, I wanted to show you what's been marked as petitioner's number 11. Can you see this document or this picture?
Yes.
And what is this a picture of?
That is the furniture that we moved in 2010 and went to the basement, and it was exposed in 2012 to mold. We had items exposed down there. That's that molded furniture, which is above my office.
Okay, so where is this furniture currently located?
In one of the fourth Jack and Jill bedroom.
Okay, and was this furniture in that Jack and Jill bedroom prior to the court having a hearing?
No.
And when was this furniture moved into the Jack and Jill bedroom?
Like September the 5th.
Okay, and this molded furniture, is it a chair and a sofa? If you would describe what it is.
It's an actual sofa and a love seat.
And this is a true and accurate picture of the furniture?
Yes.
It looks very dusty. What is that on the furniture?
That is the mold that was in the basement. Everything else was clean, but those two, Craig was supposed to clean those back in 2012 when it happened.
Okay. So, Your Honor, I'd like to admit petitioner's number 11.
No objection.
Is admitted.
Now, with regards to, so that furniture now is in the house upstairs in the house environment?
Yes.
And so what has transpired since that furniture has been in the house?
My office has started to smell moldy. My throat, I don't have like allergies, really, only food allergies, but my throat has been feeling like I was swallowing glass and I didn't understand. But I've been having respiratory issues over the
Why
last.
did you keep a moldy couch? I don't understand why you.
I should have thrown it out on my own. I threw out the rest of it, but he wanted to try to clean it, but it was supposed to be cleaned back in 2012. I wish Yana would have thrown it away then. I really do.
And as a result of the molded furniture, what has happened to you health-wise?
I'm having issues with my sinus passage in my throat. And just, I guess just allergies running. I'm not feeling well at all.
Did you go to the doctor about this?
I did.
What did they tell you?
Objection, hearsay.
What was your diagnosis?
Objection,
Oh
hearsay.
gosh, I forgot
Did they give you?
virus.
Hearsay.
Tell me what the doctor
My
said.
microphone working?
It's
There it is.
oh my gosh, I'm trying to remember the exact name of it. But it's
Sorry.
like a virus.
It's okay, Ms. Finley. How recent was it that you were diagnosed by the doctor? How recent?
That was on Saturday, which
Okay.
was, yep. On
I like to,
Saturday.
Your Honor, I'm gonna share my screen again.
Okay.
1 second. Ms. Finley, I'd like to show you what's been marked as petitioner number 12. And if you would tell us, what is that a picture of?
That was Craig's items put into one room. And so I placed it, you'll see his clothes on a rack hanging up. What I could not put on a rack, I laid them neatly on the bed, which is how I have my clothes even laid now. And then I put stuff on the dresser and I put stuff in order and neatly put it together.
Now, you did this after the ex parte was issued or after the
Yes.
court issued the order on August the 14th?
After the ex parte was issued, I slowly moved stuff into that room.
Your Honor, I'd like to admit petitions number 12.
Any objections?
No objection.
All right, it's admitted.
Now, Ms. Finley, you had indicated that you had moved the stuff over there to the bedroom. Can you explain to the court why you had moved that stuff after the ex parte?
Because what I realized, that Jack and Jill room is so small. Both times when the petitioner had broken into the room in the middle of the night, you have no time to respond. It's like they're already on you. But I saw like being in the master bedroom, being for that distance, I felt like more at ease. And so I was like, this is a better fit, because I was fearing for my safety, depending on how he came at night and awakened me during the night. That room gave me more distance or more time to prepare than being in that Jack and Jill room, because once that door opens, whoever is at that door, they're on you.
And since Mr. Finley has returned to the house, are you able to even move into the Jack and Jill rooms?
I am not. He moved both beds downstairs to the basement.
I want to show you what's been marked as petition number 14. And this is a picture of what?
That's the room that I used to sleep in, where there's a bed. It was a queen bed and a nightstand and stuff there in that room.
And when did this stuff get into the room?
When the
Yes,
petitioner
ma'am.
moved back in, like on the 14th, I guess during the 14th or 15th of August.
And is that stuff still in the room?
Yes.
And where is the bedroom furniture with regards to that was in that room that you were initially sleeping in?
It's in the basement.
Your Honor, I'd like to admit petitions number 14.
No objection.
It's admitted.
Now, Ms. Finley, you were indicating with regards to the space with regards to the Jack and Jill room. Is there beds in either room at this point?
No.
And when did the beds get removed from the bedrooms?
Sorry, just like that.
I was asking you, when were the beds removed from the Jack and Jill bedrooms?
I think on September the 5th. The 5th of September.
Now I want to show you what's been marked as petitioners number 10. If I can just share my screen again. And what is this picture of?
So that's all of his stuff in one room. I'll call it bedroom 4.
Okay. And is this a true and accurate picture of the bedroom?
Yes,
And what's all this other stuff? Is this gym equipment? What else is this?
that's gym equipment that he had in the master bedroom, his weights and everything. Those are, that's behind that gym, that's a sauna, like a portable sauna spa they have. And that's on top of the bed. I couldn't fold it down, so I just placed it on top of the bed, as well as his clothes.
And this was done after the ex parte, is that correct?
Yes, ma'am.
Now, once the court had issued the order with regards of you all having to share the master bedroom, why weren't you able to move your stuff out of the master bedroom?
It wasn't anywhere like to put my stuff. Like once I was looking at configure it, and then I was trying to hire somebody to help me kind of, because I was trying to understand how to move it and then be it in the jacket jail, because this would have been the first time that all of my items was together, because before half of my stuff was in the master bedroom and half was where I was sleeping. So moving into that other bedroom, it still wouldn't keep us 15 feet, and then not having anywhere to kind of place everything. It's difficult.
Ms. Finley, were you intentionally violating the court's order?
No, ma'am.
You understood that the court indicated that you had to remove your stuff from the bedroom, is that correct?
Yes, and I actually thought that was said the furniture too, and I was assuming that as well too.
So your reason for not moving is because of what?
I thought I had to actually move the furniture. Like I actually got someone a moving company to give me a quote, an estimate of how much. It was like over $700, and I didn't do that. But when we met last time and Yarna said I could just move my clothes, I did comply. I moved all the clothes and I left the furniture in the room.
Now, Ms. Finley, I want to show you what's been marked as petitions number 23. Ms. Finley, what is this? Is this familiar to you?
Yeah, so after I left on August the 15th, I went ahead and gave Craig, I text Craig the code, which I thought that I was giving him the code.
Did you get a message saying that he didn't get it?
No, ma'am, I did not. Like if you can scroll, nothing came back to me.
Is this a true and accurate copy of the text message between you and Mr. Finley on August the 15th?
Yes.
Your Honor, I'd like to admit petitions number 23.
No objection.
All right, it's admitted.
So you did provide him the code to the garage, is that correct?
Yes, ma'am.
Now, what was the reason for the alarm system? What about this alarm system? What happened with regards to the code to the alarm system?
I explained to him and the officer that I would not set the alarm. I would not set the alarm. So it was no need.
But you understood that the court indicated that you had to give the key. So was your impression that if you didn't set the alarm, that satisfied the court's order?
It was. I did make that assumption.
And with regards to access to the code or the alarm system, does he have access to that now?
No, he does not.
Now, has the alarm system been on since he's been back at the house?
No, it has not.
And why is there an alarm system at the house? Was it always there?
It was not. We hadn't had an alarm in over 10 years.
And when did you get this alarm system?
In August of this year, just before the ex parte.
And why did you get an alarm system then?
To help me know when he was coming and going into the house.
And why would you need to know that?
Because I feared for my safety.
Now, with regards to the keys, tell the court did you receive keys with regards to the house that the locks were changed?
I did not, and no, I did not.
Did you know that the keys that were in the door was your keys to get?
I did not.
So as of this day, you have not actually gotten the keys to the door, is that correct?
No, now that I know that no,
Now, how many locks were changed?
all of the locks.
And how many would that be?
Six.
6 locks altogether?
Yes, ma'am.
And with regards to this garage, what happened with the garage opener?
It was on the table, but when I came back to the house, it was so much stuff in the dining room, I couldn't even see what was on the table.
So let me back you up. It was on what table?
The formal dining room table.
And what day was it on the formal dining room table?
At least August the 10th when I left the house, August the 10th.
Okay. And when you returned on August the 15th, did you check the dining room table?
I did not. I just saw a lot of stuff in there. No, I did not.
All right. And so when you did return to the house, with regards to the garage lock or garage opener, did you check then once you returned to the house and see if it was still there?
I looked on the table, but I didn't see it there.
Were you contacted by Mr. Finley's attorney with regards of the keys or the garage door or any of the locks, anything regarding the house?
No.
Now, Mr. Finley had testified earlier that he doesn't communicate with you at all, does not have any conversation. Since the court's order has been put in place, has he communicated with you?
No, he has not.
Has his attorney communicated with you with regards of anything that you may have failed to do with regards to this court's order?
No, she has not.
Now, you got an ex parte before the court had a final hearing on the issue early August. Where did you get those cameras?
It's only one camera. It's a Google indoor-outdoor camera. It was outside. It was in the garage because it was an installer that was supposed to come to the home. Unfortunately, I had 2 friends to pass away in 1 week, and I couldn't meet the installer because I was at a funeral at a Word of Faith, and I asked him, could he come back another day? And unfortunately, I have not, because I would have had to move the stuff off that side for the installer to install the camera above the second garage door. That is what that camera's purpose is to go above the second garage door.
So you have not been able to finalize that because of the deaths in and I'm sorry about your friends, because of the funerals that you had to attend?
Yes, and then I just would work and everything. I had not been able to schedule, but I was paying someone to put that camera outdoors above the second garage.
Now, there was testimony earlier about a camera in your office. What is that about?
I moved that camera from the garage into my office where I keep my door closed. Now,
And why did you do that?
Because I didn't want there to be a recording of it being in the house.
Is your office in the house?
It is, but I keep the door closed. So, yeah.
So did you intentionally mean to violate the court's order without disconnecting that camera?
No, I did not.
So what was the purpose of the camera again?
It's to go on above the second garage door outside to give visibility to the remainder of the driveway entrance.
And have you made arrangements to go ahead and get that done?
No, I still have not, but I can.
Ms. Finley, there's been a lot of testimony with regards to you violating the court's order. Ms. Finley, did you intentionally violate the court's order?
No, I did not.
Did you intentionally not provide Mr. Finley any of the garage door opener or the keys to the house or any of that?
No, I did not.
Now, you previously indicated that a lot of the things that were done was done at the time that you got the ex parte. Is that correct?
Yes, that is correct.
And between the time that you got the ex parte and the time that the court entered the order, had you been able to make any of the changes that the court had indicated you needed to do? With regards to the cameras, with regards to the keys, with regards to any of the stuff?
I did disconnect the cameras. I did do that. But that was done during the ex parte. But no, I have not. I was out of town.
And since you've been in town, is there a reason why you haven't done it?
The locks were already changed. I don't have a key.
Ms. Finley, what are you asking the court to do today with regards to this motion for contempt against you?
I would ask that the court please dismiss this motion. I would ask that they remove have them to remove that molded furniture from off of up here because I'm not feeling well. And then, I mean, I would like to just go back into the master bedroom and just put all my stuff in there and just stay put until the divorce so we can figure it out.
Are you asking the court to remove Mr. Finley from the house?
Yes, as well.
Now, Mr. Finley had testified earlier with regards to his equipment and his need to be in the house to be able to do his work. Do you have any knowledge of that?
Ma'am, yes, he could do his work from anywhere. He does his work from anywhere.
And how do you know that?
I've witnessed him doing work from anywhere. I've gone on some of the trips with him and he's done his job.
And these are trips that you've gone on throughout the marriage?
Yes.
Your Honor, I have nothing further from my client other than redirect.
Cross.
Excuse me.
Ms. Finley, you were not represented at the TPO, correct?
Correct. Yes.
But you could have been, could you not?
Yes.
Okay, so by you not having an attorney, you were representing yourself, correct?
Yes.
And as such, you could have emailed me directly, correct, about anything, correct?
I would not know.
But you could have emailed me to say, hey, here are the keys, here are the access codes to the alarm system. You could have sent me that email as a pro se plaintiff, correct?
I don't even know what a pro se plaintiff is.
Meaning you're not represented. Since you did not have an attorney, you could have communicated to me directly about anything related to the TPO, correct?
No, I did not know you were representing him until we came to court.
I filed an entry of appearance, correct?
I did not see that.
Okay, so when you did file for this TPO, you were getting emails and notices about that TPO, were you not? From the court?
An email, yes.
All right, so when I filed my entry of appearance, you would have seen that I was representing Mr. Finley on this case. You did not get an email, is your testimony?
Yes, I have through that service that the courts have. Yes, I can't remember the name off the top of my head.
Okay. So let me get the timeline right. You filed for a petition for family violence, right?
I did.
All right, and then we had a hearing on that. Well, there was a hearing, you did not show up, correct?
Correct.
All right, and then you filed it again.
Correct.
And based on that petition, you received an ex parte order.
Correct.
And it was your understanding that within 30 or 20 days, you were supposed to come back to see if that family violence order was going to be extended. Was that explained to you?
Yes.
And instead of waiting for your day in court, instead of waiting for the judge to say whether or not that family violence order was going to be extended, you took it upon yourself to move my client's items out of the master suite, correct?
Correct.
Into the Jack and Jill room, correct?
Correct.
And you did not have permission or orders giving you permission to do so, did you, at that time?
No.
You said that you were afraid. All right. Is it your testimony that the two of you have been separated since 2013, correct?
Your Honor, I would object. I don't believe us talking about the separation. Ms. Finley didn't testify to that today.
I'm just asking,
We're getting into the divorce case.
no, we're getting to a history of domestic violence, Judge, and she's, if I can have some leniency here, Judge.
Okay.
All right. So you have been out of the marital resident, I'm sorry, the master suite for quite some time, were you not?
That's not factual. I wasn't sleeping in there, but I was in and out. So no.
All right. So your personal items or some of your personal items were still in the master suite, correct?
Correct.
And you were still getting ready in the master bathroom, correct? Your items are still in there?
The closet mostly.
Okay. And you kept your dirty clothes in the master suite, correct?
Yes.
Okay. And yet you were afraid of Mr. Finley, but every single morning you would still go into the space where he was sleeping to get ready in the morning?
No, he was in the living room most of the time. The master bedroom would be empty. He slept on the couch most of the time.
And again, Your Honor, I would object to, Ms. Johnson made it perfectly clear that I could not bring up anything with regards to the TPO, we were just here today for the motion for contempt, and that's it. But she's getting into domestic violence in the TPO. Now, if the court would like to extend that same courtesy to me, my client can testify with regards to those issues with regards to domestic violence.
I'll just move on, Judge, but just
No, thank you.
you testified that you could not move into the Jack and Jill bedrooms because there are no beds in there, correct?
Correct.
But you could have gone to Solomon's room, could you not? There was
I'm in
still a bed
Solomon's
there.
room now, but I could show you how
I'll
I'm
take that as
living
a
though.
yes, Judge.
Yeah.
So you could have moved into Solomon's room and you decided not to.
Correct.
All right. And you know that we did file this motion for contempt, oh gosh, back on September 7th, correct?
Correct.
And you still did not move your items out even after we filed this contempt action against you, right?
Correct.
You didn't do that until this weekend, correct?
That was a little after we finished court the last time. I moved my things out.
All right. And you said that you moved your items out of the master bedroom. What about the bathroom? Have things been moved out since?
Everything is completely moved. Yes.
When did you move the things out or your personal effects out of the master bathroom?
A day after our last court date.
Which was last week, correct?
Yes.
Okay, so you were testifying that the reason you didn't move out of the master bedroom is because, according to you, there was no room in the Jack and Jill rooms, right?
Correct.
So what stopped you from moving your personal items out of the master bathroom?
There is speaker and personal effects from the petitioner all through that bathroom as well, across the hall.
Ma'am,
Mhm.
you understand that you were ordered to not only move your personal effects out of the bathroom, the master bathroom, you were supposed to move your personal effects out of the bathroom as well, right? You do understand that.
The master bedroom, everything is moved from the master bedroom and bath.
Okay, but you didn't move the items out of the master bathroom until this weekend or shortly right after Judge Manning said you're giving a few more days to abide by her order, right?
Correct. Correct.
All right, so you gave an explanation as to why you did not move out of the bedroom, which that may or may not be accepted by Judge Manning. That's up to her. But you didn't really explain to me why you didn't move your personal effects out of the master bathroom. Do you have an explanation as to why you divide that part of the order?
The bathroom and put it where?
How many bathrooms are in that house?
4, and they
4.
are all occupied.
So
with
Judge
stuff.
Manning ordered you to pick a bathroom and to pick a bedroom. Okay, you
Yes.
gave him a reason, sort of an excuse, as to why you didn't abide by that order pursuant to the bedroom. But what about the bathroom? There are 3 other bathrooms you could have chosen from. Why didn't you move your personal effects out of the bathroom up until recently?
For me, I wanted Solomon's room and Solomon's stuff to be off limits. So that wasn't even a consideration in my thought. And the other bathroom, the Jack and Jill bathroom, is occupied with Craig's stuff. The bathroom downstairs is a guest bathroom, and there is no room for my stuff in there. So my stuff is actually in the hallway on the catwalk.
So in other words, in part, the reason you did not move your things out of that bathroom as Judge Manning orders you to do so is because, to use your words, you didn't want to, correct? You
That's
don't want to,
incorrect. That's incorrect.
ma'am. When Judge Manning issued her order and she said y'all are going to VRBO the master suite, did you put a lock on the master bedroom door?
Yes.
Okay. Did you provide my client with the key to that lock?
No.
And it's still your testimony that you are not in willful contempt of Judge Manning's order.
Yes.
I have nothing further, Judge.
Your Honor, I like to do some redirect. Miss Finley, with regards to the lock to the bedroom, when was that put on? Was that put on at the ex parte or after the court issued the August 13th order?
The ex parte.
So at the time that you all came to court, that lock was already on that door. Is that correct?
Yes.
And with regards to the bathroom, you had indicated that you were trying to respect your son's bedroom and didn't want to put the stuff into his bedroom. But after court last week, before the judge, you recognized that the court says, get your stuff out the bathroom. Is that correct?
Yes.
Was that a willful intent of your part to just defy the court by leaving your stuff in the bathroom?
No.
And your stuff is where now?
And on the catwalk in the hallway outside.
Now, you had indicated earlier you didn't understand what pro se means. Do you have a better understanding of that now?
A little bit.
And at the time that you were representing yourself with regards to the TPO hearing, were you aware that you had the ability to communicate with opposing counsel?
No, I did not. No.
You're right. I have nothing further with regards to this issue.
Anything else, Ms. Johnson?
No, Your Honor.
All right. Okay. You have anything else, Ms. Babb?
Nothing else, Your Honor.
All right. Hold on 1 second. I got a couple of questions. Let me look at my notes. All right. So the first one is, who's going to change the code that was shared on the screen for, I think it was the alarm system? Because now everybody, if there's anybody watching, has that code. So somebody needs to change the code because that was broadcast over YouTube.
Thank you, Your Honor.
Number two, and let me ask the lawyer first. So both of these individuals own rental houses? Like separate rental houses? How many rental houses are they and who lives in?
Yes, ma'am. There's 2 for Craig and 1 for LaQuasha.
Are they all rented out?
My home is rented out, Your Honor.
Okay. What about his? Mr. Finley, what about the 2 you own?
That is correct. They are both rented, Your Honor.
I mean, there's stuff packed up all over your house. Every room is full of stuff.
Yes, ma'am. It is.
Why? Has it always been like that? I mean, y'all have a basement, and why bring this ratty couch covered with rolls upstairs?
Your Honor, may I respond to that?
If you're going to respond directly to what I asked, yes.
All of my things were placed in that one room, and I had nowhere to go through and figure out where my underwear, my socks, my deodorant, or anything. And so I had to try to organize myself, and I was doing it under the duress of knowing that I had to go on a trip where I was a speaker at an IBM event. If I had moved my things as you ordered, I would know where everything was. I did not touch any of her things.
Why'd you bring the oldie couch up from the basement? I don't even understand. Why did you bring stuff up from the basement? What? I don't even understand.
All right. So in that moment, although she moved her things out, she left kids' toys in the closet and I needed space to just lay out my stuff. If we go back and look at that picture, all of my things are laying on top of furniture. And I mean, I'm really trying to get back to work, do my job, and then prepare for the next place that I had to go. So when I went downstairs, while I had day laborers and help with it, the blue couch that used to be in the master bedroom that was transported to the basement, I told those guys, yeah, you might as well bring that up as well, because I plan to have it treated, and it was treated last night. It is clean. I had it professionally treated yesterday.
No, it's not clean, Your Honor. It still smells terrible in here throughout. And it never was in the house. I don't understand why he brought it up either, Your Honor. It's never been in the house.
Because I don't trust the bed that you
I'll
left.
talk to her.
Yes, ma'am.
And Your Honor, also the green sofa that I moved to the basement, I only moved that large green sofa, and you didn't see that. He put that green sofa in the dining room. So that green sofa is now in the dining room in front of the formal dining room table. He could have easily, I wouldn't have even said anything if he slept on that green sofa in the dining room, because that's the only place it could fit. That would have been okay, but I don't understand why he brought that sofa and love seat up there. Your Honor, I apologize.
When I did this here, I said, we're going to treat that like a VRBO. Both of y'all can pick a bedroom. And you take your little suitcase with your clothes in there, just like you were staying a weekend at a VRBO. I don't know what was so hard to understand. I know I have an accent, and I have been, like I said, I like to say, I know I've been told it sounds like cornbread and buttermilk when I talk. But, you know, treat it like a VRBO. Pack a back, take a room, move your stuff into it. 1 week. I mean, I did it like people do children. One Saturday to the next Saturday. Week on, week off. Week on, week off. One, to make a point, it's ridiculous. This is ridiculous. This is honestly ridiculous. I emailed Judge Williams Chambers again to get y'all, because y'all are looking at sometime in 2023, and
Thank you.
y'all got it. This is War of the Roses. I guess you're not tearing it up, but you're stacking crap everywhere
He is.
and making it unlivable. I mean, you say, well, if you can live in that room, you can get in that room. Everybody wanted to keep Solomon out of it, but you stack everything stacked in there in his room. I told you, he's not going to want to go home and be in between all this anyway. If he walks in that house, he's going to see what's going on in there. Oh, God. Kitchen, you can't go anywhere in the kitchen. I really try to be creative in some of these.
Yes. And Your Honor, I don't want him to see this if he comes in November, because it's like
Your Honor, you
stuff
know,
stacked on the bed. I don't.
a lot of commentary, and my client is biting his tongue.
Oh, I know.
Not forget that she's the one who put him in the middle of this. But I'm going to stop. But if I want to stop, then she needs to stop too, Judge, or my client needs to be able to talk to you.
No, both of them giving me a whole bunch of commentary, but.
Now, Your Honor, we did not get the chance to address the attorney fees. I had the docket checked. It's not on the docket for the divorce case or the TPO. I'm not sure where Ms. Johnson filed it at. But I did have my staff check, and I don't have any record of it to be able to. Not on the docket for the divorce case or the TPO. I'm not sure where Ms. Johnson filed it at. But I did have my staff check, and I don't have any record of it to be able to at least have some questions regarding it.
I can pull it up.
Does the attorneys have anything final to say so I can make my ruling?
Your Honor, this is Ms. Johnson's motion. I don't know if she wants to speak first.
I can speak first, and I'm looking at the stamp filed copy of my affidavit and attorney's fees now, so I can email that to the court, Judge. But by way of argument, Your Honor, her own testimony tells you that she defied your order because she didn't want to do it. Her own testimony says that, you know, the reason she filed this for this ex parte and family violence order is because she was not happy with the fact that we're going to wait until 2023 before we can even get in front of the judge for a final hearing on the divorce. And I understand the court's frustration, and I'm right there with you too. This is absolutely ridiculous. But my client had already been in that master suite since 2010. He had already been sleeping there. He had already been getting ready there each morning. He occasionally slept on the couch, yes, and he testified as to why he was doing that. But it's Miss Finley who has taken upon herself to basically do self-help here, and she used the TPO proceedings in order to gain an advantage in the divorce action and to get her way. That's exactly what she did. She went down and she filed for this petition for family violence on bogus and inaccurate information and just falsified facts here. And Your Honor, thank you for seeing straight through that. You made no finding of fact of family violence. You saw right through it. But that gave her just enough time to do exactly what she wanted to do, to stir the pot, to get up under his skin, to get back into that master suite. That is exactly what she planned on doing. This is calculated. And so far, she's gotten away with it. Now it's my client who has been living in that master suite all this time. And he would testify, and I think he already did, that all of his things were confined to that master suite. I absolutely agree with you. I saw the pictures. He and I have been talking about this since the very beginning. And that is, she has her things thrown all over the house. She has occupied the family room. She has occupied some of her things still in the master suite, even though she doesn't sleep there. The vanity in the master bathroom, she still had her things there. She still keeps her dirty clothes in the master suite. She still has things piled up in the Jack and Jill room. She's all over the place. And he was trying to keep the peace and saying, okay, fine. Look at her own exhibit, Judge, that photograph that she introduced into evidence, where you can see that all of his things were in the master suite, including his workout equipment. He is trying to keep the peace and stay away from her and wait his turn for his day in court. And she has done this. And you're absolutely right. While he was out of the house doing that ex parte order, it was Miss Finley who did all of this while Solomon was still at home. Mr. Finley testified he found out that his things were moved out of the marital suite from Solomon. She has done this. So I don't think it's fair that the one person who has not only violated this court's order, not only has she refused to wait for her day in court, there are several hundreds, if not thousands of people in the same situation as they are in because of the backlog. You have to wait your turn. Not only has she, acted as if she's more important than everyone else who needs to wait for their day in court, she's violated this court's order. She's abused the TPO system to gain an advantage in a divorce. But what gets me is that so far she's gotten away with it. And she wants you, Your Honor, to issue an order to allow her to continue to do so. Either issue an order stating that he has to move out when I really haven't heard anything where he's done anything wrong. I get the furniture. He'll move the furniture back down to the garage if that upsets the court. But other than that, substantially, he has complied with this court's order. In fact, he has complied substantially with the standing order. He's trying not to step on her toes. He's trying to stay away from her. But she, for once, is not getting her way. And this is her attempt to get her way. I'm asking your court, the judge, to rule that she is in willful contempt of court. She did install those cameras, and they are activated despite your order. Keep in mind, those went up after you said that everything is supposed to be taken down and disconnected. She did basically barricade herself in the master suite. She changed the lock in the master bedroom, did not provide my client with the key to the master bedroom. She did go in and move his things. She should not have been touching his things. She should have waited for him to come in so that he knows exactly where everything is. He was abiding by your order. And she refused and failed to do something as simple as move your things out of the master bedroom and move your things out of the bathroom. There are 4 bathrooms in there, in that house. She could have picked 2 of them, really, if she really wanted to.
There are 4 bedrooms. Are there 4 bedrooms also?
There are 4 bedrooms and 4 baths, is my understanding, Judge.
Okay.
She
All right, go ahead.
is in willful contempt of court. And what makes this sad, and I'm frustrated, is because he has now been billed, starting at 12 o'clock this afternoon, he has been billed $5,737.50 on this TPO. That's actually a lot more than what I've actually billed him for that underlying divorce, because we're patiently waiting our turn, waiting for our turn. We are asking for reimbursement. I don't know why they're not seeing the affidavit in support of my fees. It is filed. I'm looking at it right now. If I may, that affidavit in support of attorney's fees was filed on August 4th. And I'm looking at it right now. I'll try to share my screen again, but we don't know how that goes.
I've got Odyssey. I can.
You have it. All right. So, I'll just wrap up with this, Judge. Normally, I will say it takes 2 to tango. It takes 2 to fight. I've been talking to my client. He's accepted that this marriage is over. He's accepted. He's ready for it to be over. He has to wait his turn. He has to wait for his day in court. He's patiently waiting for that. Okay. I'm not hearing where he's done anything. Maybe the furniture, maybe. But other than that, what has he done in violation of your order? This is all her. That's all I have, Judge.
Your Honor, on behalf of Ms. Finley, the court did not hear our position of what he has violated because our motion for contempt was not heard today. So let me start with that. But he has also violated the court's order. Your Honor, on behalf of Ms. Finley, I think what's really interesting today is that Mr. Finley, as a counsel, is trying to portray him as he is being a victim in this matter. But I think that the court had the right question of who would bring molded furniture upstairs and put it in the house. Now, for some people, that just seems like something trivial, that's not a big deal. But for those of us who work in the criminal and the civil and the family law cases, we all know it's strategic. It is a way to affect somebody. It is a way to intimidate somebody. It is a way to let somebody know that I am going to do whatever I want, whenever I want. But see, I'm not going to do this particular item because my attorney told me not to do that. But my attorney didn't tell me I couldn't fill up both rooms of the Jack and Jill rooms. My attorney did not tell me that I could not change the locks or, reach out to my son to see if he has the keys that I can get into the house. Your Honor, Mr. Finley is not a victim. The court did not allow us to get into the evidence with regards to what it should have been heard with regards to the TPO, and I understand that. We are here on the contempt matter. On this contempt matter, what you heard today, Your Honor, is that your order was issued. My client was out of town. When my client returned in town, she came with the police, she got some items, and she left. You have a video that was shown indicating that the officer asked her about, some code. She didn't give it right then and there, but we did provide the text message, and I apologize for putting it, full blast because I forgot that the court was recording on YouTube. So that is my fault for that. But nonetheless, she did communicate with him. And he indicated during his testimony that she should have received something back saying, you've been blocked. We showed you the text stream, Your Honor. She did not receive anything. She did not have any knowledge that he did not obtain that information. You've heard testimony from my client with regards to the garage key opener, the garage door opener, that where it was placed at, and when she went to go look for it, it was no longer there. She did not willfully fail to provide that to Mr. Finley. If anything, she tried to stay out of his way. She stayed in the master bedroom after the court order was issued because she had no other place to move to because he had filled the other rooms. And he even testified that there's no way to sleep in the other room. The only room to take was Solomon's room. I'm a parent, Your Honor. I generally probably would have left my kid room alone and not go into that child's room. But everybody has their own personal views as to whether she should have took Solomon's room or not. And even taking Solomon's room, it still does not allow her to remove all of her personal items. We talk about my client's items being all over the house, but we didn't talk about how Mr. Finley's items are all over the house too. These people lived in his house and they got stuff everywhere. Now, the garage had stuff in it, the basement got stuff in it. He tried to explain to the court that he moved the moldy furniture up there. For what reason? And after the court issued an order that you need to pick one in a room, so why would you pick a room that one of you can sleep in and make it impossible to sleep in? He admitted his testimony that there are no beds to sleep in the Jack and Jill room. So now the real question for the court is, you have an order in place that says the parties are supposed to pick a room in the house and rotate from the master bedroom to that other room. Well, Your Honor, where was Miss Finley supposed to rotate to? And his testimony was Solomon room. So does that mean that the parties were going to rotate Solomon's room and the master bedroom? I don't think that was the court's intent when the court entered its order. I think the court's intent was, you guys have a couple of spare bedrooms, you can use that. But Mr. Finley made that impossible for Miss Finley to comply with the court's order. Your Honor, is my client perfect? I'm not saying that she's not. But what I am saying today is, now my client is sick based on Mr. Finley's action by creating a dangerous situation, putting her health at risk. This is a person who says, oh, I'm trying to keep the peace. This is a person that says, I'm not doing nothing wrong. Well, putting a person's health at risk, Your Honor, is something wrong. Putting a person's health at risk, Your Honor, is endangering their life. Now, it may not be extreme as putting a gun to somebody's head, but I don't know if the court is aware of when people get ill with mold in their system, it can become deadly. Your Honor, Ms. Finley is not in willful contempt. And I'll be honest with you, I'm not sure what the remedy is for the court today with regards to this situation. My client filed her protective order because she is concerned for her safety. I like to call it nice nasty. That's the game that Mr. Finley plays. I'm not doing nothing, but he's doing something behind your back and you can't really tell what's really going on. I'm not doing nothing, but I'm moving stuff over here so you don't really know what's going on. At the end of the day, Your Honor, my client is not in willful contempt. The number of things that they are alleging that she did based on this contempt were things that were done prior to the court's order that was entered. So she did not violate the court's order in that sense. She was under the impression that she was supposed to move her furniture along because, you know, she has said that to me, that the court said I had to move my dresser, my nightstand. Maybe that was her misinterpretation when you told her to remove her personal items. But nonetheless, once she understood what the court indicated that she needed to do, she made sure that she took care of that and she moved out of that Your Honor. With regards to this camera issue, Your Honor, she testified that the camera is supposed to go outside, but she has not been able to have the people come in and set the camera up because it is a Google outdoor camera. Your Honor, we're asking the court to find that my client is not in contempt, willful contempt of court. We're asking the court not to award attorney fees. Again, I have not been able to see the bills. I've had my people check Odyssey. They weren't able to recover those bills. I believe $5,000 for a TPO may seem to be a little extreme with regards to the TPO and a motion for contempt. But again, my hourly rate at $425. So I don't know until I look at the bill so you'd be able to ascertain whether that is reasonable or not. Your Honor, we would also ask the court schedule our motion for contempt against Mr. Finley because this is, it takes two, and this is a situation where we believe that my client is not in contempt, but that he is in contempt, Your Honor.
All right.
May I finish my closing, Judge?
Correct.
All right. First of all, Your Honor, they could have brought to the court's attention any allegations that my client has violated your order. I think what they're trying to argue, Judge, is unclean hands. That's a specific defense that could have been pled in their response. They didn't do it. Secondly, Your Honor, ignorance of the law and procedure is not an excuse not to abide by it. Ms. Finley decided to show up at that TPO hearing unrepresented. And as such, she is put in the position and she is expected to be able to present herself as if she were either an attorney or as if she were represented by one. So that's just, you know, that's no excuse. Third, Your Honor, even if you do consider some of the allegations that they're making against my client, that he's in violation of your order, which he's not. Nothing that they're claiming that my client has done, including moving up the furniture, is a direct violation of your order. It isn't. Unlike the behavior that we have discussed that Ms. Finley has been exhibiting since the issuance of your order. And fourth, Your Honor, finally, I'm sorry, I don't understand why the cameras are there. I don't understand why she installed those cameras. I get what she's saying, that she's waiting for someone to install those cameras on the outside. She did not give a reason as to why the cameras are plugged in right now. She did not explain away the camera that's in her bedroom or her office space. She's not supposed to have it. And again, it goes back to what I said earlier. She does what she wants to do. She did not disconnect the camera out of the garage or the camera in her office because she didn't want to. She didn't give him a key to the lock to the bedroom door that you said is supposed to be rotating. The occupancy of that is supposed to be rotating on a weekly basis. She didn't do it because she didn't want to. Whatever she does not want to do, she won't do it. That is why we're asking for the relief we're seeking here today, that she be ordered to either vacate the marital suite, the master suite, so he can move back in, like he's been there since 2010, or vacate entirely, Judge. That is what we're asking for. And as far as attorney's fees, this is probably the most I have ever charged on a TPO. It really is. But let's not forget that my time announcement, Judge, was 30 minutes. And of all the testimony that I've presented, I would wager most of it probably does not even amount to 30 minutes, Judge. This is all on Ms. Finley and her attorney. We are asking for those reimbursement of fees.
All right. You folks give me a couple of minutes. I'm going to try to call Judge Williams Chambers right now. I'll be right back and tell you my decision.
Thank you, Your Honor.
Thank you.
Ms. Johnson. Mr. Finley.
Hello.
All right. So I don't know what this house looked like ahead of time. I mean, there's rolling. Mr. Finley. Are you watching it, Mr. Finley? Because your screen just lit up like you're watching it in the background on YouTube or something. So yeah, you're watching the stream instead of paying attention to what's going on. That's why I'm hearing myself in the background. I mean, there's rolling. All right, so obviously you can get this in sooner if Judge Bryce hears it. That's what Ms. Walter just said. They're also going to try to get y'all on sooner, but as long as you follow 1004, people are just prolonging it. I think they need to modify those so that issues can be heard instead of this. But I will say, like I said last time, I want that master bedroom. I want all the drawers empty. I want everything out of the bathroom. Personal belongings. Shampoo, deodorant. I want it to be like you went to a VRBO or a hotel room to check in for a few days. That's what I want. Sorry, I keep going blurry on here. That's what I want. That's what I said before. And that's what I want now. And here's what we're going to do, because y'all need to sell this house. And if I was somebody, I'd probably ask to leave a court, put that thing up for sale. Because y'all are just like the War of the Roses. And I'm not making light of anything other than the situation here where you can't figure out who's going to sleep in what room. Because since I've been doing this hearing, probably 100 people have been killed. People have lost their lives. Some to violence, some to illness. And we are sitting here because, one, ma'am, I said, take your personal stuff out of there. You think for some reason, all of a sudden, if you haven't been staying in there, you got to pick up a nightstand and take it out. He brings up crap from the basement that's moldy. There's stuff sitting in every room. I don't know. Like I said, Solomon probably doesn't want to come home. He can't get in the front door. He can't move around. But what we're going to do is that master bedroom is going to be cleaned out, not pack it. Mr. Finley?
Your Honor, I can show you the video to show you that it's empty today.
Okay, that's fine. Great, because at least you took my advice to clean everything out. So it's empty. And it's going to be just like, when you leave, strip the sheets off the bed, you wash them, bring your own linens. Period. But it's going to be week on, week off in this house. Because y'all don't need to be in the same house together. You can't engage common sense, sir, and you, ma'am, that one, the way you get arrested for violating things is because you called the police. And for some reason, you didn't think that keys hanging out the door, ma'am, on a pink key ring had anything to do with a house key. It was in the door. And sir, you spent all that money, ridiculous. You could have easily went by and got the keys from your son. Or something. You could have done something other than spending all that money. And then you just had the couch cleaned because it was just done yesterday. Where are you going to put it? Why did you even have it cleaned? You had it cleaned to be stacked up in the living room and stacked up everywhere? Insane. Insane. Think of it as going to camp. So, sir, you just sit there and said, I'll sleep on the couch. You're making a big deal about, week on, week off, Saturday to Saturday. It's like it. Well, I think I made it Saturday. Did I, Miss Johnson?
Yes, you did, Judge.
Okay, sorry, it was just pulling up. It's slow pulling it up. When one person gets there, and they go in that master bedroom, that's not going to have cameras, locks. The bathroom's going to be cleaned. The sheets are going to be stripped off the bed. You can bring your own bed linens. It's going to be, you're going to vacuum, mop the floor, sweep the floor, whatever you got to do. You're going to clean it and leave it, or you're not going to get your deposit kind of thing. How about that? Okay. Bring your clothes like you're going to stay somewhere for the week or for the week. And you're just on a week vacation at home, sir. You did stuff while you were gone for work. So take stuff that you can work on somewhere else. Go into an office space. You didn't always work remotely, so there should be something you got to do. Y'all, honestly, somebody needs to kick a renter out and move into the rental houses, because if your properties weren't rented, that marital property would stay empty and each would go to a rental house. And Miss Finley, you're being difficult, but Mr. Finley, you're just as difficult. You are just as difficult every time you open your mouth to answer a question. You just can't answer a question. I still never really got how much anybody makes, but you spent that money to unlock the doors. That's money out of your pocket, because you could have thought about, let me go by and see my son so I can get the keys. I'm suggesting somebody withdraw 1,000 forces y'all can get in front of one of the JOs. I want to set this down for a compliance to see how this is going in 30 days. I have given you both, 3 hours of time? 3 hours of time. Everybody's heard everything. I've looked at pictures of, just stuff piled everywhere. Kitchen, living room, all these bedrooms. I want to bring y'all back in 30 days because I want to see how this is going to go. Because if somebody comes back and you're not leaving that room clean and you're not doing anything else, both people, y'all are going to kick your renters out and y'all are both going to find somewhere else to stay. Ms. Bay, I think you said it before, that you thought maybe that I, had some preconceived, ruling or something on this case when I said Judge Williams won't put up with this. I'm telling you, ask any lawyer that's been in front of her in Fulton County, she is going to be livid. I suggest y'all find a really good mediator, try to mediate this case. I want to put this back on. Everybody look at your calendars, because we're going to see how everybody's behaving in 30 days. I'll look at your, if both of you want to send me I'm giving some fees because I think I was very clear on my order, how it was supposed to be treated and why you didn't communicate about the keys, the code and all this. Cameras. I have absolutely no problem with camera outside of the house. Yeah, was the garage inside the house or outside the house? Seriously. If they are inside, they are not to be. They're to be taken down, unplugged, disconnected. What other word do we need? Put it away in a box, put it in the basement, put them in the moldy couch. I don't want them operating in that house. Now, ma'am, when you're there, if you want to put one in the house, maybe you're scared something's going to happen, the little indoor, outdoor, you can put it in there only while you're there. That makes sense. Sir, you can do the same thing. The week you stay there, you can put a little indoor, outdoor camera in the house. But they do not stay up when the other party, I will not have the other party looking in on somebody. Don't touch one another's stuff. But right now it's all marital property. So you can touch what you want to. Council, do y'all have your calendars up? If somebody leaves the place a mess, destroys anything, changes a lock, does anything, makes anything more complicated than it is, I promise both of you will move out of that house. This is just, and you guys have a grown young man in college. I can't believe you stayed, married this long. I've got October the 10th. Does Mondays work for you folks?
Yeah, Anna, can we do it the next week? Well,
Let's see. I know we're getting the 7th.
Your Honor,
October 24th to 17th. I already have something that's special set.
Your Honor, I'm scheduled for a trial in Hall County on the 10th in person.
What about the 24th? And Ms. Johnson, when you email the order for fees, you just leave the amount blank. I printed off a copy of your affidavit. And if you want to e-file a new one or updated one or email one to Ms. Bea and to me, that'll be great.
Okay. Do I get an opportunity to challenge the fees at all?
Yeah, I'll hear from you in a second, but right now I'm trying to get a new date. I'm going to let you go ahead and do it right in a few minutes. But I'm trying to get a new date set. Because I got to get off here in 30 minutes to start my criminal stuff for Orca. 24th, does that look good, Ms. Johnson, Ms. Bea?
What time, Your Honor?
Right now, it looks like it's open. Ms. Free hasn't said anything for me, so it could be really 9:30. I don't know if one of you have anything.
I can do the afternoon.
Ms. Johnson?
I'm wide open, Judge.
All right, when you folks say afternoon, tell me what, is that like 1-ish? Tell me what.
1, 2.
1:30 would be great, Judge.
Okay, 1:30 will actually work because that way I won't have to stop for my ex partes. And Ms. Free is off on a very much well-deserved vacation, so I'll get her to send a new link and stuff when she gets back. I think she's gone. I know today.
Maybe here tomorrow, Judge. I'll make a note on her screen.
All right, so she can do it. So she can do that tomorrow for that day. All right. Go ahead, Ms. Bea. I've got her affidavit pulled up, her attorney's fees affidavit. She's made it. So go ahead. Do you want to ask Ms. Johnson some questions? She's an officer of the court. She doesn't need to be sworn in.
Your Honor, I would like to see the bills. Were the bills attached to the affidavit?
He filed on 8/4. And after August the 4th, there's one that's e-filed. It's in Odyssey. I'm looking at it.
If I can just have a moment, Your Honor.
Okay.
Thank you, Your Honor. Your Honor, first I would object with regards to the affidavit because these are not actual bills. with regards to what has been done and performed and what was billed to the client. I understand that she's testifying to the work that she had performed. But again, I don't know whether this reflects what has actually been put on his bill or whether he's even been billed this particular amount of money. If I could just have a second.
Okay.
And I can respond to that. Yes, he has been billed, Judge, for that time.
Okay.
Ms. Johnson, with regards to your entry for July 13th, you indicated that it took you 1.2 hours with regards to preparing a motion for a continuance, exchange with the divorce judge, email the TPO judge. So you have included with regards to this particular entry, documentation or charged your client with regards to the TPO and the divorce case. So what exactly was for the divorce, for the TPO hearing?
Because your client had filed this frivolous motion for the TPO, my client was displaced from the marital residence. I did ask for an emergency hearing to be heard by Judge Williams. That still we have not been able to do. But it's a direct result of having to respond to Ms. Finley's fraudulent or false application for family violence.
And I guess my question for you is that this is based on the TPO or based on the divorce case?
It's based on both. I had to file the
So did you just,
motion.
I'm sorry, go ahead.
I had to file the motion for the emergency hearing because my client had been wrongfully displaced from the marital residence and he was worried that he would not be able to do his job. So I did both. And I attached, I believe, her petition for the family violence as an exhibit to my motion for the emergency hearing.
And with regards to the fees that you indicated that you have incurred since appearing for court, you did not update an affidavit with regards to those, whatever work that you performed since the August 4th court date, is that correct?
That is correct. And I can definitely do an updated affidavit and charge my client another 30 minutes to do that if you want me to. But in an interest of saving my client's retainer, I stated in my place at the date of the hearing that he has incurred additional fees, one being the court appearance, that was 2 hours. I prepared the temporary order as I was instructed to do so by Judge Manning. That took me an hour and a half. Once your client was in violation of the order issued by Judge Manning, I had to prepare my motion for contempt of court. That took me an hour and a half. We had that court appearance, although we were there for quite some time. I only billed my client 0.5 for that because, you know, we didn't spend that. We only spent about 30 minutes on the actual case. And then as far as since then, let's see, we had the court appearance on September 14th. That's 2 hours of my time there. I had to prepare for today's appearance, look at and pull together exhibits that was provided to me by my client. That took me about an hour to do. And of course, today I've been sitting with you good people for 4 hours now. I've been here since noon. Probably what's going to be reflected on my client's bill, to be honest with you, because I was able to get some other work done while we were waiting for this case to be called. I'm probably going to knock off an hour. So instead of 4 hours, it's going to be reflected on this next bill is probably 3 hours.
Thank you, Ms. Johnson. Your Honor, our position with regards to Ms. Johnson's affidavit and Mr. Finley's request for attorney fees, we believe that the evidence today demonstrated that Mr. Finley also is not in compliance with the court's order, that my client should not be charged, would have to pay any attorney fees with regards to this matter. And we would ask that the court not award attorney fees with regards to Mr. Finley's request.
And in response to that, Judge, the proper way of putting in an argument for unclean hands is to actually file a response to the motion and put that in there. She has not done that, so she cannot just use it now. It's untimely to make an unclean hands argument, Judge.
Your Honor, we also would like to bring to the court's attention that we also do have a pending motion for contempt with regards to Mr. Finley's violation of the court's order as well. Again, our position is that both parties may have had some issues with regards to complying with the court's order, and that my client should not be penalized for the behavior that Mr. Finley has done in her trying to defend herself with regards of staying in the marital home longer than she should have based on his actions and making it difficult for her to move out of the master bedroom.
And again, Your Honor, the reason that their counterclaim for the contempt is improperty before this court is because they filed a response. They filed a counterclaim of contempt in response to the underlying contempt action, which they're not supposed to do. They're not allowed to do that. So one has nothing to do with the other. Ms. Finley is entitled to her day in court as well. And when she does have her day in court, she can also make her argument for attorney's fees, but that has nothing to do with what's before this court today.
All right, so if you will, like I said, you can submit a proposed order for attorney's fees. You can just leave the amount blank. And if you want to email the updated invoice, Ms. Johnson?
Yes.
And I know one was there anything that was done in the divorce that you need to parse out separate?
If anything, Judge, it would be the motion for the emergency hearing. They're so interconnected that I added to do. So if you like, Your Honor, I can actually take off that hour.
Or if you want to know, if you want to just know.
Bifurcate it. I could bifurcate it, Judge.
Okay.
Your Honor, I just want to make sure that I'm clear on the court's ruling today with regards to the motion for contempt. It's my understanding the court is saying it's Saturday to Saturday, week on, week off, being in the house. What date will that start?
This weekend.
Your Honor, is that rotating the house or rotating the marital suite? And we're putting it down for compliance. Do you want both of the parties to vacate the marital residence?
Yeah, I think that's best. I think that's best. I think that's probably, if anything's doable, that's doable. I really don't know. I'm kind of at a loss, as to what. Yeah, they need to vacate the residence.
So starting on September the 24th, and who's to vacate first, Your Honor?
So whose week was master bedroom week this week?
Judge, she's been in violation of that order, so he hasn't had an opportunity to get in there at all. So if anything, he should have this weekend, Judge.
All right, so he would go first. Now, do I have to say, leave the kitchen clean. Don't eat each other's food. I mean, don't be a bad roommate. Everybody, I don't know, maybe y'all have had roommates, maybe you haven't, but don't eat one another's food. Don't leave the place a mess. Take out the garbage. Do all of that you're supposed to do just to be a decent human being. Honestly, just be a decent human being just for a little bit. Just for a little bit. And maybe I want to exchange discovery and try to mediate this. I don't think Judge Williams would have let y'all go this long, but I wanted to hear everything, and I will. And each time you come in front of me, I promise it'll be reset and I'll check your behavior. But right now, I'm really interested in how people are going to behave for the next 30 days. So I forget what time we had to vacate, Ms. Johnson, but you get that time to vacate, leave an hour so that the other can come there. House, I mean, it's got to be clean. I don't know how you clean the rest of the house. And sir, get the moldy. Rent a storage unit and get the moldy couch out. I mean, come on. I don't know what you're just going to leave it stacked up somewhere. Make this place livable. I mean, for real. Nobody can do anything except go in there. I don't even know what the master bedroom looks like now. Don't want to know, but that's all they can do. You should be able to live in this house, use the kitchen, use the living room. Look like the garage was the neatest part of the house. But you get, like I said, if it's for safety, you want to have a camera inside while you're there. I get it. If someone's there by themselves, they may want something for safety, and that's fine. But take that camera away, taken down, boxed up, not recording, one outside. Nobody. And if there's an alarm code, you both share the alarm code. Most alarm codes now, there can be two different codes. You still are married. You both still own this house. Does everybody have keys? Thumbs up or thumbs down? Because I don't want anybody to say anything. All right. How does Miss Finley get a key? Her thumb is down. How does she get a key?
Mr. Finley will leave it on the kitchen counter.
How can she get in if it's locked?
She has the code to get through the garage.
So don't lock the door between the garage and if it goes into the kitchen or whatever. Don't accidentally do it, Mr. Finley. Don't say, whoops, it's habit. If I find out that that door from the garage into the house is locked and she can't get in, I'm going to lose my mind.
What about the lot to the master suite, Judge? She still has that. He doesn't have it.
I will give it to him.
Is it okay? You're gonna be there by yourself? So are there two keys? You're gonna get? I mean, I don't know why there's a lock on there if you're there by yourself, but yes. Where are you gonna leave that key?
I could put it in an envelope, leave it on the table.
Okay, a table. I didn't see a cleared off table. Is there a place that's cleared? How about you leave it on?
I cleared the island off. I could leave it on the kitchen island. It's clean. I just cleaned it off.
All right. How about that then? So obviously, she's gonna need to get her stuff out of there. And it looks like he's probably at the house. Where is he? Where's Mr. Finley right now?
Mr. Finley, where are you? At the house?
They're both at the house.
Y'all both sitting there doing this. Oh, good God Almighty. All right.
No.
So, sir, grab whatever you need. Get out for a little bit. Give her time to get some things together and get out.
And then he's moving back in on Saturday, and the two of them rotate the house from there, right?
Well, yeah. So, whoever is going to stay, the other person, if you're staying there, leave, give them a couple of hours to grab some stuff and get out, and then go back home. So however long y'all need to grab some things to get out, or whoever, then do it. And then he comes back.
Yes, Your Honor.
So however long he would need or whatever. Now, don't go if his office is private and she's got a private room that's an office and neither one of you have business in there, don't go in there. Just don't.
Thank you.
Don't go in there. Don't go in where he's staying. Don't go in. Just leave that stuff alone. That's work. So just leave it alone, please.
Thank you for clarifying.
Anything else that I need to do to make anything clear to anyone? Bills are being paid.
Who's going to prepare the order, Judge?
I thought she just told you.
Am I preparing the order? Can I charge another? I'm going to have to bill them another 45 minutes to do the order.
That's fine. That's fine because I have criminal bond hearings in 45 minutes and I don't have time because I got to finish prepping my calendar.
I'll do that. If I may, I think there has been some issues about the utilities being paid and having access to be able to pay those. Mr. Finley, thumbs up or thumbs down? Is everything, y'all have access to continue paying the utilities, correct? Just very, very briefly.
No.
It's a joint account. He can use the joint account. That's what all the bills stuff is put. It's still established a joint account and all the bills are paid out of bill
standing
pay.
order is still in effect, Judge, and that nobody is to cause the disconnection of any of the utilities going into the marital residence. That's a standing order in place, Judge.
Right. Is
Established amount that I should put in that account?
what do y'all normally do? That's what a standing order is.
Well, a lot of those accounts were changed and disconnected, so I don't have information of where to pay it, but I can put the money into the joint account. I did not make the changes. That's why I don't know where stuff should be paid to.
Only one bill was changed, just a light bill. So the joint account though, it's all still there. And I put that in, it goes to straight bill pay, Your Honor, and goes directly to those entities that's due.
So there's nothing that's about to get cut off.
No, ma'am. No, ma'am. Mr. Finley didn't pay for 2 months of mortgage, but I still paid it. Nothing's about to get disconnected.
So if we can if any bills or utilities have been changed, we put in that order that the bills are supposed to be provided to each other. If it's in Ms. Finley's name, she is provided to bill to Mr. Finley. If it's in Mr. Finley's name, he is to provide to bill to Ms. Finley. And then he continues to pay, or they both continue to pay as they have been doing through the duration of this marriage.
Does that mean he's going to go back to paying the mortgage?
Okay, y'all want to get into the divorce now? We're not going to do that because I got some people that are in Fulton County Jail that need to get out or want to get out.
Your Honor, the last thing I had to ask the court was whether you're going to schedule our motion for contempt. It was a separate motion that was filed.
Well, here at that same day, it's on the we'll hear it on October
3rd, 24th. Yes, ma'am.
Yeah. At 1:30. But I strongly Yes, you guys try to work some of this out, because seriously, you two people are paying tuition for, you're paying back, if they still have student loans, y'all are paying their
Amen.
off, or you're paying for their children's college. And I think you've got a child that's in college, which is probably where you'd both rather be spending your money.
Amen.
So I don't need your commentary there. Okay. So, how about y'all think about that when you talk to your lawyer? And I know they want you to help pay their student loans off because they want to make money, but, I don't know that there'll be another speaker at Morehouse that's going to pay off everybody's student loans, pay off everybody's tuition. So y'all may want to save that money for yourself and for your children. All right. Madam Court Reporter, thank you so much. Don't forget, everybody, Madam Court Reporter gets paid within 5 days of receiving invoice. And 5 days receiving invoice, okay? Because I just had a case the other day where a guy waited 6 months before his client wanted to pay take down, and all of a sudden he was primed for a copy of the transcript. Right? Anybody else got a question?
No, Your Honor.
No, Your Honor, thank you.
Counsel, both of y'all, please speak with one another and get your clients to work. Get them to work on it, because they really don't need to be back here for anything. They honestly don't.
I agree, Judge.
You know, and Miss Bea, Miss Johnson, I don't know, but I'm sorry for your loss.
Oh, Ms. Free told you what I said. Thank you.
Yes, I'm sorry for your loss. I guess you can tell Miss Johnson offline, but I'm very sorry for your loss. And I will keep you in my thoughts.
Your Honor, I just wanted to make sure the court was aware. It wasn't recent. It's just who the person was to me.
It's a child. Doesn't matter. Like when lost my mom. Doesn't matter what it is. It was like yesterday, I'm sure. So
you're right, Your Honor. I just didn't want the court to think that I misrepresented something.
no, absolutely not. So you folks stay healthy and safe. Y'all have a good week, and you can email it to me. Thank you so much. Anything else, Dr. Taylor?
You received your calendar for tomorrow.
Okay.
But you will receive a full markup in the morning.
Ms. Freeze taught you well, Dr. Taylor. Mr. Finley, if you have any questions, it's probably for your lawyer and not for me. Am I right? Mr.
Yeah.
Finley?
Yes, Your Honor. I don't understand what the question is. What are we talking about?
We're not talking about anything. You're the one that did this like you had a question.
Oh, no, you said that we were done and I was just waiting.